Yeah, the fact that the girl has to freaking, I have to freaking go back in here and fix this thing in here. I really do. I really, really do. Let's see what we got live. What's going on live right now? My folks, where my people at? Where, I can't even see y'all. I can't even see y'all. Let me stop coming. All right, let me see. 8 people. Hey, Tally. Hey, TK. Hello, people. Hello, hello, hello. Now, mama want to call me back, girl. Stone you, girl. I'm going to call you back. I need to fix the thumbnail for whatever reason. I didn't add it on her when I was going live. Y'all know we all behind this stuff. I'm all over the place. One, I'm extremely excited about the visit that I just had. Because y'all know I told y'all know I have my law school today. I have my law school today. I didn't even have a coat off. I don't even have a coat off yet because I had a law school visit today, okay? So I decided to go with, just a little, okay, for one, I need the temperature high. I need this joint rotating because it's extremely cold down here in my office, like extremely cold down here in the office, and it's crazy. So I ended up, I just went with, I just went with a blue turtleneck, Roddy blue turtleneck, because that is the school colors, y'all. The school's color is blue, so I wanted to come, you know what I'm saying, in style, okay, representing. Anyway, I did a blue turtleneck with some jeans, and I just did Uggs because y'all know it is cold here in St. Louis. It is super cold. It is not snowing. We are not going to get any snow. We are actually getting ready to warm up. Like tomorrow, it's gonna be like, today it's gonna be in the 30s. We warming up over here. So I did that, and I did my Uggs, and then y'all saw I had my big coat on because it's cold out there. So yeah. Went to the school, y'all. The school is amazing. It is in downtown St. Louis. I do have some content. I'm going to put it together, edit it, and do a voiceover for it so y'all can see me do my visit. I didn't record too much on it because I was asking a lot of questions while we were going through because I need to know if this is where I want to go. So I seen the library. I seen, they're like, they don't have like a cafeteria because the law school is actually centered downtown St. Louis. It's actually downtown St. Louis. And it is separate from the main campus. So the building just only houses law students. So no other people or undergrads are going to be able or will be in that building outside of us. Y'all, it is also located right next door to the courts. So if there's something interesting going on and I want to go sit in the courtroom next door, I could go. Now the school offers full-time and part-time education. They have a bunch of different law clinics. They've got one for criminal, family, and it's and they getting one for health law. All right. I met a few people. I talked to a few students, y'all. It was just everything. It's my number one pick. So I wasn't gonna come out of there with nothing bad anyway. I will say that the only thing that was like, oh my God, that kind of had me worried a little bit is like if I got a sick kid or something, if I do go full time and I go during the day and like one of the kids gets sick, like the support system gonna have to be on their P's and Q's for the next 3 years because sis can't be missing class. I can't be missing class for a running nose. I can't be missing class for appointments and things. You know what I'm saying? So the support system gonna have to step it up. I'm putting it off on them. Yes, I've supported everybody in every way that I can. And if I get into law school and I go full time, everybody gonna have to pick up. Everybody gonna have to pick up their slack. I don't care. Pick up the slack. Take that boy to that appointment. Take that girl to that appointment. And that's just how it's gonna be. That's just how it's gonna be. So I just want to tell y'all I had a good time. I'm super excited about it. I do think I'm going to get accepted into SLU law. It's going to be great. And I want to just go ahead and I guess just get us started. We are watching the Arbery trial, and we are on day 10. It's the defense's case in chief, so they are putting on their case. They've called their neighbor, some gal up here, and now the the state is getting ready to cross-examine her. So here we go, y'all. Yes, I'm all in the comments, y'all. Let me do let me do what I'm supposed to do. Okay, let's share.
You own a black car, right?
Yes, sir. Oh, yes, ma'am. Sorry.
It's okay. You can call me sir. No. But you were coming in, and Officer Duggan was. Hey, Mr. Perez, how you doing?
Good. How are you?
I'm good. We've met before and talked, haven't we?
Yes, ma'am.
All right. So, on the 23rd, you own a black car, right?
Yes, sir. Oh, yes, ma'am. Sorry.
It's okay. You can call me sir. No. But you were coming in, and Officer Duggan was speeding right past
Yeah, somebody.
you. Okay. And you went down. Diego said, "No, keep going."
Yeah.
All right. So you took the kids home.
Yeah.
But he wandered on down to the scene. Didn't he?
Yeah, he wanted to, what in the heck? You know, it was pretty gruesome sight to come up on. So he wanted to know what happened.
All right. Now, let's talk about, I'm going to kind of back up and we'll talk about crime for a minute, okay? Now, you guys had never been the victim of crime up until this June 30th, 2019, when the tools got stolen out of the unlocked car in your driveway, right?
Yes.
All right. But you guys normally locked your cars, right?
Well, see, that's the thing with his truck. It actually had to go to the shop because Ford had some kind of problem where you would lock the truck and it would stay locked and then it would unlock itself. So he thinks he locked the truck. We said he locked the truck and come to find out the truck was having issues. So,
Gotcha.
yeah.
All right. So, as a Facebook administrator, you're just the person who's kind of like letting people join and that kind of thing.
Yeah.
All right. But after the theft of the tools, you decided to go ahead and get some cameras.
Yeah.
And you're willing to share with the neighborhood the images on the cameras. Mm-hmm. And you talked about the Facebook being used for things like water power, animal control.
Yep.
Okay. Kids selling cookies, that kind of thing. Charity events.
Yeah.
But your husband's not a member of the Facebook page.
My husband does not do any kind of like log social media, nothing.
Okay. So he's not paying attention to what's going on Facebook.
No.
Now, your husband went ahead and volunteered to help out Larry English, right?
Yes.
So he's the one who made contact with Larry English to say, hey, I'm willing to go ahead and assist you, live 2 doors down.
I think I had messaged his wife and gave him or her Diego's number and said, hey, you know, this is my husband's number. If you'll have your husband reach out to him, please. And that's when they had a phone conversation.
Now, when you asked Amy English, can we put up these trespassing signs? Was that before or after this homicide?
I couldn't tell you.
Okay. You think maybe it was afterwards?
You can look at the Facebook messages. I honestly don't know.
Did you private message her or?
Yeah, private message.
So it's not going to show up, do you think? All right.
I don't know. I don't know how that goes.
Did they ever, before this incident, put up any no trespassing signs?
I don't know what they did on their property.
Well, did
I
you
don't
see
know.
any no trespassing signs?
They had a bunch of different signs up, so I couldn't tell you what one was and what one wasn't.
Okay. All right. And you're really close with Subi Lawrence?
Yeah.
She lives across the street?
She does.
All right. And that's who your husband's also close with. You guys know each other for a very long time, right?
Her mother.
Okay. Annabelle Beasley.
Yes.
And they live right next door.
Mm-hmm.
And you were talking to Subi about what took place in the neighborhood, right? You were informing her.
Mm-hmm.
So, the problem with Larry English and his cameras is the camera goes off, he gets it on his phone, and then by the time he watches it, he calls Diego. Is that right?
Now we know that's right. We thought he was calling the police and then calling Diego, but we've learned after talking with you that that was not the case. So yes,
He was just calling Diego direct,
unfortunately, yes.
not calling the police.
No.
And your husband had had it with that, hadn't he?
Yeah, once he realized on February 11th, that's when he said, you don't ever have to worry about me. I'm not doing that again. Like, what in the world? Why would you put myself in danger like that?
Because he thought on February 11th that Larry
Called the police, yeah.
Larry hadn't called the police.
No.
And so your husband gets this Facebook message, or this text message.
Yeah.
I misspoke, the text message. And he goes over there because he's trying to be a good neighbor.
Yes, ma'am.
He actually went into that house, didn't he?
Yeah.
He went
And
in
he's went in the house so many times. So.
and when he goes in the house, he's usually going, private property,
No
private property.
trespassing, yeah. What are you doing here? I've heard him yell that, like, what the hell are you doing here? Obviously not seeing anyone, but trying to get a reaction out of whoever is there. Yes.
Because he just wants the person to go away.
Who are you? What are you doing here? Don't come back. This guy doesn't want you coming back. You know, you're bugging us. You know, what's going on?
So on this night, though, on the night of February 11th that we're talking about, remember that night?
Yes.
Okay, so Diego goes out of the house, he goes over there like he's normally doing. Does he have his high-powered flashlight with him?
Yeah.
Okay, and he's got his gun with him. And you come out the front door and you see Travis and Greg and Michael.
Yes.
All right, they're in Travis's pickup truck?
I think Travis might have been driving. I don't remember if Mr. Grant, I said, I don't remember if he was walking by the truck or if he was in the truck. But I remember seeing both of them.
All right, and so they're coming back from which direction?
From their house towards the front of the neighborhood.
Okay, and you're communicating with him, telling him what?
I was trying to tell him, like, hush, hush, because I mean, he was just so, la, la, la. I'm like, who are you talking to? Shut up. What are you doing? I didn't realize until, later that he was on the phone with 911. Thought he was talking to his dad, so.
Gotcha. And Greg Michael, did you see him then go into the house as well?
I didn't see him go into the house because of the stuff, like Larry had a trailer and stuff, so you can't see like the front of Larry's house from my driveway looking over, but you can see the front yard, and I saw, his truck, he pulled it up in the front yard with his bright lights on, and Greg might have went in, but I think Travis stayed. I remember seeing Travis at the back of the truck.
So when you say Travis pulled the truck up, where did he pull it, on the street or somewhere else?
So say this is the front yard and this is the street, he kind of, I think it might have been hanging out in the street, but I know, he pulled it up and he had his light shining on the house.
And you were afraid Greg Michael was going to go in there and shoot your husband.
That's why I was trying to tell him, hush, my husband's in there, letting him know, hey, if you come across someone, it's not, I didn't know how they, got down there. I didn't realize that Travis had saw the guy or any of that. I thought, oh gosh, Larry English is telling someone else in the neighborhood, and now, they're going down. Like, holy cow, this is not going to be a good situation if he didn't know my husband was in the house. So that's why I was trying to let him know, like, hush, Diego's in there,
Because you knew that they carried guns as well.
I didn't know them to know that they carried guns.
You didn't know them like that?
No, I didn't.
Right. But you were afraid that if they had a gun, they'd find your husband and shoot him.
Well, I knew that my husband had a gun, and I didn't want them to see my husband with a gun and just think he is this random person in the house and he's armed. So therefore, we need to bring a little bit that's what I just wanted them to know. Hey, that's my husband in there.
Now, let's go ahead and talk about, I want to make sure I cover this. Oh yeah, with regard to Larry English and the missing stuff on his boat, he told you he suspected his subcontractors, right?
No, Diego actually told him. He didn't say he suspected anyone, but Diego said, well, what about the people with the tool bag? When they came out, is the tool bag heavier or fuller than what it looked? And he said, well, it might be, I'll check it out. I don't remember if he actually did come back and say, I know he came back and said, I asked them, but I don't remember if he ever said, yes, it was them. But I'm thinking that he didn't because we didn't know who had taken it. So I'm thinking if he said it was my HVACs, we wouldn't still be thinking somebody, is taking this.
Okay, so I want to make sure, because we have our subcontractors, okay, and then we have the white couple from November 17th who also went into the house.
Yes.
So you're talking about
the white couple is who I assumed was a subcontractor, because the kind of tool bag he took is like an electrician bag, well, typically an electrician bag. So that's what I assumed was a subcontractor.
So you assumed that the white man and white woman who had gone into Larry English's open unsecured construction site on November 17th, 2019 were actually some of his subcontractors.
Yes.
And that they'd gone there to rip him off or steal some stuff.
I did not think that. My husband thought that.
And he told that to Larry?
Yes.
Okay. But I guess my question is, did you, or to your knowledge, your husband, were you guys ever informed that Larry actually suspected his own actual subcontractors, the HVAC guys?
I was not aware that Larry suspected that, no.
So Officer Rash never told you that either?
No.
So on December 8th, we're talking about December 8th, and Renee Herndon posting about her car getting broken into.
Yeah.
Okay. So you remember that post?
I do. What page was that again?
Let's go ahead and flip to page 356. Okay. All right, so do you remember Renee Herndon on 12/8/2019 talking about thieves broke into her truck last night, her husband's truck, and stole his guns?
Yeah.
Okay. And you then responded, black male, short hair, tattoos on chest and arm.
I was asking if
that was the description, right? And she says it's hard to tell. But the police showed us a picture of the guy you're talking about.
Yeah.
All right. And we're going to keep an eye out. It was Officer Rash, and he sounded like he's pretty familiar with all the suspicious activities that's been going on in our neighborhood. This is getting ridiculous, is what she responded.
That's what she wrote.
Okay.
Renee Herndon.
And did you then check the cameras for her that night?
Yes, I did.
And you saw a suspicious car?
I did.
And did you also see the pictures that Renee Herndon had posted
in the
about the guy?
I think she posted it later on.
Oh, I know. Here. So I'm going to show you what's already been marked and admitted. It states 327A and 327B. Are those the pictures that she had posted?
Yep, those were the ones she posted.
And did you ever, did Officer Rash ever follow up with you all and tell you that it was a white guy who had broken into their Jeep?
No.
You didn't know that?
No one ever followed up with us or anything, so. Yeah, because we had pictures of the car, or what we assumed was the car, and they never came by to get those on a USB. So
the police never came by to get anything from you guys about the car?
about any of this, no.
Let me make sure I've covered everything, okay? All right, Mr. Press, I'm gonna hand you back over to the defense. They may have some more questions for you. I don't know, okay?
Ms. Perez, could you describe the lighting conditions at 220 Satilla Drive at night?
There's no lights there. I know we had a street light put in, I don't know when, because there was no lights.
Did the darkness, the lack of light at that location cause you even greater concern if there's an intruder coming in that late?
Just because it was so pitch black dark, literally, and no lights around, it's kind of like, why kind of thing. But
Not just a looky-loo looking at architecture.
you can't see anything in there that late at night. I mean, I was only there once at night, but the night that I was there, you couldn't see really anything.
The state asked you about the Renee Herndon incident in which weapons were stolen out of their cars. When she posted, "It's getting ridiculous," what did you understand? Page 356. What did you understand her to be talking about? It's getting ridiculous.
There were several car break-ins. Like backpacks were rummaged through, and some kids' backpacks were found in the different yards and stuff. There's just a lot of suspicious activity, a lot of people coming and going into Mr. English's house, and it's just an uneasy feeling to not know, who it is, and the cops are being called, and they still don't know, who it is. It's just not a good feeling.
Thank you, Ms. President.
You're welcome.
All right, thank you, ma'am. Yes, you may step down.
Thank
And you are released.
Karen, she's also under arrest. We're going to reserve the right to recall.
I'm sorry, you are subject to recall, but you're excused today. Thank you. Next call is Jack Brinson. We're told truth, whole truth, and nothing but the truth.
I'm out.
Yeah.
Sorry about that.
Yeah.
We have a 5-minute break. We're working together.
Let's do this. Sir, I'm going to sue Jerry first. Ladies and gentlemen, we're just going to take a very short recess. Plan to come back probably the next 5-10 minutes.
All right for the jury.
Drama girl, it was so good. Like, I really think that I secured my spot. I don't know why they won't let my comment post, but yes. Taylor takes loss. It's going to be a hell of a story.
All right, sir.
And in my glove box, and everything was thrown around, and I keep a bunch of quarters in an ashtray.
Aware of.
At the first, my experience was probably about 6 years ago, where my vehicle was broken into, and I didn't realize it until the next morning when I went to go get my coffee, and you could see someone had been in my glove box, and everything was thrown around. And I keep a bunch of quarters in an ashtray in that car just for tire pressure, things like that. And the ashtray poured out, and the quarters were gone.
Let me stop you there. What kind of work do you do or did you do?
I was a sales tax and withholding tax auditor for the compliance division of the Georgia Department of Revenue for 30 years.
Okay. Did anything happen to some of your stuff related to your work in terms of being stolen?
Not that I know of.
Oh, okay. You were saying then that you had some things stolen from your car.
Yes,
And that's-
CDs and things like that, but nothing really of value.
Okay. Do you know whether or not your wife is a member of the Facebook Satilla Shores page?
Yes, she is.
And are you aware whether she posts on that page?
Yes, she does.
Okay. Do you all discuss the types of things that are posted on the Facebook page as it may relate to crime?
Yes.
Okay. And I want to ask you if you ever became aware of any crime as it relates to Larry English's house, 220 Satilla Shores.
Objection to hearsay if this is based on the Facebook page.
Well, it's not based on the Facebook page.
or whether he heard it from his wife, who got it from the Facebook page.
I'm just going to ask him if he's aware of it. I haven't gotten to the hearsay part just quite yet. Just want to establish a little foundation, if he's aware of what's going on in the neighborhood. We're asking about if he's aware of crime. Are you aware of any thefts occurring in Larry English's home?
Yes,
And did you come to understand the type of things that were stolen from his home? Without saying what you were told, did you become aware of the types of things that were stolen in the home?
yes, and also a dollar amount.
Without going into what you were told, okay. And do you recall who you learned that from? Just the
Various,
name of the person or persons?
various people.
Can you name them?
I would say one would have been Matt Benzie, maybe Taylor Zachary, maybe, I don't know, probably several other people. Word gets around.
Did you discuss these types of things with your wife and your daughter and your son-in-law?
Yes,
Did you all make any changes in your habits to try to address or deal with some of the crime that was going on in the neighborhood?
yes. After that first instance, as minor as it was, we had fake cameras at that point, and we bought a camera system ourselves. And
So you had fake?
yeah, we had, try to just let someone think we had a camera system.
Okay.
So then we actually went out and bought actual real cameras.
Okay, very good. That's all I have. Thank you, sir. The state may have a couple questions.
No questions, Judge.
Thank you, sir. You may step down.
Okay.
I understand he can be released. And, sir, you can step down and you are released. Thank you.
Okay, thank you.
Can I call Annabelle Beasley?
Sir, tell the truth, whole truth, and nothing but the truth.
Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
My name is Annabelle Beasley.
And Miss Beasley, where do you live?
I live in Sitilla Shores, 225 Sitilla Shores, Brunswick, Georgia.
And how far is that from Subi Lawrence's house?
Next door,
Could you tell the jury how you related to Miss Lawrence?
she's my daughter. And since she's single, divorced, I asked her to move next door so I could keep an eye on the kids.
How long have you lived in that house?
Since 2004,
So 16, 17 years?
longer than that.
Longer than that. My math is wrong. And you mentioned your grandchildren, Subi's
No,
children.
1994, I'm sorry.
1994. Okay, so it's not my math, it's your math.
My math was.
All right. And you mentioned grandchildren. How many kids does Subi have?
She has 3 boys.
And how old are they?
Right now, the oldest is 15. I have a 13 and a 10.
Please describe for us the type of neighborhood Sitilla Shores is. Certainly when you moved in 1994 and as it's gotten
When I
closer.
moved in 1994, it was an older neighborhood, a lot of seniors in there, and it was quiet. I think my kids were the only 2 daughters that grew up next door, grew up right there. They went to high school they were in Sitilla Shores, and so we didn't know a whole lot of neighbors then because a lot of seniors tend to keep to themselves. But in the last few years, things have evolved, and the seniors have moved on, and we've got younger families in the neighborhood.
So more children in the neighborhood.
That is correct.
Do you know the children who live across the street at the Perez residence?
I certainly do.
Okay, how do you know those kids?
I know those kids really well. I've known them since they were little because they went to the daycare with my little grandkids.
Okay.
Yes.
Um,
And I've known Diego since he was a young boy at Sunday school. And then we reconnected, and then I found out that he's buying a house across the street from me. And I said, what a blessing.
Okay. That's wonderful. So the neighborhood was elderly. Now it's more younger families. Do you live with anybody in your house?
No.
Okay. Do you do anything to maintain your own security at your house?
I have recently, after all the happenings in the neighborhood, it was unnerving. And so I had to, when she's single, she couldn't defend me. I got to protect myself. So it became necessary to have cameras put up.
Okay. And you have cameras at your front door or what parts of your
I
house?
think I only have one at the front door.
Okay.
And that was put on recently, so.
Okay. Did there come a time when you yourself became the victim of a property crime?
Yes, I did.
Can you tell us about that?
Well, I was in China, and my black Honda was sitting in my driveway, and my kids, I communicated to them every day, and they discovered that the car was broken into, the door was wide open, and they had been in, so they saw that it was all ransacked. And I asked my daughter if she reported it to the police, and she said no. because the week before, somebody's Jeep was broken into, and the police said, you should have locked your door. There's nothing we can do about it. And since my door was unlocked, she decided not to call the police.
Mm. Did you end up, when you came home from China, calling the police about it or anything?
No, it was way past, yeah.
Okay, so it's a crime that's unreported to the
That is correct.
Okay. Did you become aware of a situation where Subi's cameras, Ms. Lawrence's cameras, went off one night in 2019?
She told me about it.
Okay.
Yes.
Did you, as a result of what she told you, did you do anything about that?
Not personally, no.
Didn't change security, didn't change
No.
your...
I have a security system in the house.
Right. It was like an alarm system.
Right.
Okay. Now, you mentioned that Ms. Lawrence has three
Boys.
kids,
Three
three boys.
Mhm.
Are you aware of those boys ever going across the street to Mr. English's house to borrow some pieces of wood?
Nope.
Okay. Are you aware of them ever playing at Mr. English's house?
They played with Mr. English's son.
Ah.
And Mr. English's son would come across and play with them. And Mr. English, when they were using scrap wood to make a ramp, he said he would build them a ramp.
Okay. And do you know if that ever happened?
I don't know.
Okay.
I don't know.
Did there ever come a time when your grandchildren became too afraid to play outside?
Yes.
And do you know what happened?
Well, I think they were scared by what they saw. And when they called their grandmother one night, I wasn't there, and their mama was at the birthday dinner, and they saw somebody. Pardon me?
No, not yet. You can sustain or overrule that objection.
Yeah, this is what she heard that the boys were reacting to.
Okay.
That's the same.
Let me move past what they told you. Did there come a time where they stopped playing outside at night?
We wouldn't allow them to.
You didn't allow them. You say we, you're talking about you and Miss Lawrence.
Uh-huh.
Okay. And why wouldn't you allow them to play outside?
Because we didn't want them to encounter anything, you know.
I think it's all still based on hearsay from what you heard from either the board or somebody else. So the reaction to what they're allowing them to do because of that is still based on that hearsay.
Let's focus on this.
Yeah.
Sounds like she made a decision. Let's figure out what her decision is. Why?
Right, and that's what I was trying to do, Judge. Do not tell us what the boys told you, but did there come a time when they stopped playing outside?
That's correct.
And you said you didn't want them to play outside.
Correct.
And tell us why you and Ms. Lawrence made the decision not to let them play outside.
Because of things that were happening in the neighborhood. We didn't want the boys out there. We didn't want them to confront or see anything that they shouldn't. You know, we didn't want them to be a victim of anything, so we let them stay inside.
Safety.
And even to today, they barely go out except now that they're older, they will play. But as long as we are home, it's okay for them to be out there. But they do go across to Perez's house, and we're okay with that.
As long as they're being
They're
oversight.
right, exactly.
Was there a time, Ms. Beasley, when you were interviewed by GBI agents?
Yes.
Okay, do you know when that was?
When the incident occurred,
The incident being the shooting of Mr.
that is
Arbery?
correct.
Okay, and you gave a statement to the GBI?
Yes.
Okay, all right, that's all I have. Thank you, ma'am.
Okay.
I just have a couple questions. Good afternoon, ma'am. How are
Good
you?
afternoon, fine, thank you.
I'm Paul Camarillo. I'm part of the prosecution team.
Nice to meet you.
We may have talked on the phone,
I
I
think you
believe.
did. You and I had a long conversation.
We did, right?
I do remember that
Okay.
now,
Is
yes.
it a good one?
Yes, it was a good one.
Okay.
I think I told you all that I was thinking.
You did.
Mhm.
You did. You did. And not all of that is relevant evidence.
Okay,
All right?
gotcha.
So I just got a
Okay.
few questions for you, okay?
Mhm.
You've been in the neighborhood a long time.
Right.
Okay. Is it fair to say that a vast majority of these crimes that occurred in the neighborhood were property crimes, or car break-ins and that sort of thing?
Correct.
Okay. Other than the homicide of Mr. Arbery, violent crimes were few and far between or non-existent in the neighborhood. Is that correct?
That is correct.
Okay. Ma'am, that's all I have for you. Thank you.
Thank you.
May she be excused?
Yes, thank you, ma'am. You may step down.
Thank you, sir.
Does she understand the subpoena?
No.
All right, and you are excused. Thank you.
Thank you.
That's called Subi Lawrence.
Swear to tell the truth, whole truth, and nothing but the truth.
So help me God, yes, I do.
Good afternoon.
Hi.
Ms. Lawrence, I'm going to ask you to introduce yourself to the jury.
Okay, my name is Subi Lawrence, Subelawrence.
And we just met your lovely mother, but I want to make sure she spoke loud enough. I want to make sure you speak loud enough so that last jurors back there can hear you, okay?
Yes, sir.
Okay. Ms. Lawrence, what kind of work do you do?
I'm in recruitment.
Okay. And how long have you been in, like a headhunter kind of recruitment?
Mhm.
How long have you been
15 years.
Okay. Here in Brunswick?
Yes, sir.
Okay. Do you have any concerns about your job and being here at this trial?
I do.
Okay. Well, what are you concerned about?
I obviously just don't want any negative impact in my career and personal life.
Okay. But you're willing to testify today?
Yes, sir.
Okay. Could you tell us where you live?
I live at 221 Satilla Drive,
And where's that in relation to Annabelle Beasley?
right next door.
Okay. And where is that in relation to Larry English's house?
So he's kind of catty cornered. If you're facing away from my house, he is across the street and one over.
Okay. Do you also know Brooke and Diego Perez?
Yes.
And how do you know the Perez's?
My middle and her oldest went to preschool together, and then just since moving to the neighborhood, have become friends.
When did you move into Satilla Shores?
August 2015.
Okay. Was there a time before you moved in 2015 where you lived in Satilla Shores?
Yes, sir. I moved there in 9th grade with my family, my mom, dad, and sister, into the house my mom lives in 1994.
Okay. And at some point you moved out?
I did. I got married and moved out and got divorced and came back.
Okay. Okay. And so how would you describe your relationship with the Perez's?
Oh, very close. They are definitely good neighbors, good friends, like other parents to my boys. One time we actually had, the boys were playing baseball in the front yard, and a ball went through the dining room window, and Diego just happened to hear glass crashing and runs over, and he had it repaired before he went to bed that night. And then Brooke's over with her vacuum cleaning up all the glass. So they look out for us.
So they're neighbors that help you
Yes.
with all the
Yes,
things,
sir.
the
Yes,
three
sir.
boys, right?
Yes, sir.
I want to go back to 2019. How old were your three boys at that point?
They were 8, 11, and 13-ish.
Okay. Did they have any kind of relationship with Mr. English or his children?
Yes, Hoyt, Mr. Larry's son, and my middle are about the same age, and so they would play together. And Mr. Larry actually gave them some wood for a ramp, for bicycle ramp.
Okay. Have you ever seen Mr. English's surveillance video of two boys on his property
I have.
on bikes?
Yes,
Okay. Do you know who those boys are?
those are my children.
Oh boy. And what were they doing in that video, to your understanding?
They were going to get the plywood for the ramp Mr. Larry made them.
Okay. So they had permission essentially to get the wood.
Yes.
Okay. Did they ever go into Mr. English's house at night, to your knowledge?
No, sir.
I want to take you back to October 2019.
Okay.
Okay. Was there a time when your camera on your own home security system alerted you?
Yes, sir. It was late October, and it was late in the evening. So I want to say the boys and I were at a football game or the fair or something on a Friday night, maybe that was, that had us out late, 10 o'clock-ish, I guess. And so I got an alert on my Blink cameras that, there was motion detected. So I look at it and I see two men with flashlights looking at the front of the house. And so, of course, I call Brooke and just say, there are guys at my house with flashlights. Can you please send Diego over to see what's going on?
Okay. And why would you ask Brooke to send her husband into a difficult situation?
Because Diego is...
I asked her why. Yeah.
I feel very safe with Diego. I know that he would look out for me and my boys, at all cost.
Okay. And did you eventually come to understand who was on the camera that alerted you? Did you ever find out?
Yes, I did. Diego came over and figured it out and relayed it through Brooke.
Okay. Did you ever, as a result of that incident, talk to the police?
No, sir.
Okay. Did you ever post anything on the neighborhood Facebook page?
In general, yes. About that specifically, I don't recall.
When you say in general, what kinds of things were you posting on the neighborhood Facebook page?
Who do you use for landscaper? The ice cream truck is in the neighborhood. Just kind of general neighborly, keep you updated sort of things.
Okay. Did you ever post anything about crime in the neighborhood?
I didn't initiate a post. I may have commented on a post about crime in the neighborhood.
Okay. Any of those posts related to Larry English's house?
I don't recall specifically.
Okay. Were you kept informed of the intruder in Larry English's house over the course of the late fall 2019 and early 2020?
Yes, sir. So if Brooke would find out that there was a suspicious person lurking, she would usually text or call me and say, tell the boys to get inside and lock the doors. The guy's back at Larry's.
And what would you do when she would tell you that?
well, kind of at this point, the boys were staying inside a lot anyway. So, I mean, you know, I would still tell the boys, don't go outside, stay inside, lock the doors.
Were your boys, would you describe them as physically active young kids?
Very.
And so were they, before all these break-ins, playing outside?
Always.
Okay, building ramps for skateboards
Yes, sir.
and riding their bikes. Were they outside at night?
Mhm.
Do you know when that you stopped them from playing outside at night?
I didn't have to stop them. As you know, reports of car break-ins and suspicious persons, you know, lurking around, they kind of did that themselves. They didn't want to even come help get the groceries out of the car at night because they were just, you know, just a little afraid.
Okay. As a result of your awareness of break-ins in Larry English's house, did you take any security measures to protect yourself and your kids?
Before I knew about the break-ins at Mr. Larry's, I had read on our Facebook page about a car being broken into. And so after that, I got the Blink camera system.
Okay. And were you kept aware about crime in the neighborhood through your neighborhood Facebook page?
Yes, sir.
Did you find it to be helpful?
Very helpful.
Okay. Did you, were you ever one of the administrators of the Facebook page?
Yes, sir.
Okay. And again, what does that mean to be an administrator?
So just to have access to who's joining the page, what kind of things are being posted in the page. We wanted to make sure that they were actually people that lived in our neighborhood or, you know, had a legitimate reason to be in the group.
Okay. Did you notice over the course of when you moved back in 2015, anything about crime in the neighborhood, whether it was rising or falling or?
Growing up there had never been crime. And, you know, I'm ashamed to say I didn't always do a great job of double checking that my car was locked. But when I started to see frequent posts about cars being broken into, and not only in our neighborhood page, but the Exit 29 Facebook group, people would post from the neighborhood next door. So of course I was just a little more diligent about making sure that, you know, the car was locked and the doors were locked and windows that I hadn't checked and that sort of thing.
Did Brooke Perez or any other neighbor or the Facebook page for that matter ever inform you about how many times this black male was coming onto Larry English's property at night?
Not so much the Facebook group. It was probably more just text from Brooke saying, you know, get the boys inside.
Okay. And when she would text you that, would you make sure the boys were inside?
Yes, sir, absolutely.
Okay. How did that make you feel, the fact that there was someone coming over?
Violated. Upset that my kids weren't getting to grow up in the safe neighborhood I grew up in. Previously, we lived on some land, and we had a dirt driveway, and all they wanted was a neighborhood with roads so that they could ride their bikes. And so to have to say, come inside, stay inside, or Mom, I don't want to go outside, it was just disappointing.
Even though it wasn't violent crime, it still affected you and your boys?
Well, crimes of opportunity may not start as violent crimes. It's just someone's in the wrong place at the wrong time, and I didn't want my boys to be home alone and someone think because there's not a car there, there's no one home, and then they're in that situation without me.
Right. Okay. Thank you, Ms. Lawrence. Appreciate it.
How are you?
Hey, well, thank you.
My name is Paul Camarillo, and I'm one of the prosecutors here.
Yes, sir.
We've never spoke before, right?
No, sir.
Okay. I may have left you a voicemail too, but we never actually connected, right?
No, and I'm sorry if I missed that.
Oh, it's okay.
Definitely would have called you back.
No, it's okay. Would you?
Yes. I'm very afraid.
All right. I'm not that scary.
Okay.
You and Mr. Rubin were talking about break-ins at Mr. English's house.
Mm-hmm.
Nobody there actually ever broke into anything. Is that correct? That you know of? It wasn't a secured house. Somebody walked through the door.
I don't know if there were even doors.
Right, there weren't. But
So Mr. Camarillo, that's testifying.
Just as your sons went in that garage, open garage.
Yes, sir.
You're not aware of any sort of doors or windows or anything else that was on that property?
No, sir.
All right.
At the time that we're speaking of.
Yes, ma'am.
Okay, yes, sir.
Currently, there might be.
I think so.
Okay. All right, so you're friends with the Perez's, close friends, right? Y'all had dinner together? Exchanged texts and calls and that sort of thing? Y'all went on a boat ride with the Perez's and Mr. Michael?
Mr. Greg and Travis. Or Mr. Greg and Ms. Lee.
Yeah, right, okay. And that was shortly, that was after the homicide?
Yes, sir.
Y'all talk about friends and family, that sort of thing?
On the boat ride?
No, I'm just in general.
The Perez's and
Yeah.
Oh, yes, sir.
Okay. All All right, and then after the shooting, you and Brooke walked over there, or kind of meandered over there to see what was going on, right?
The day of.
The day of.
Yes, sir.
Okay, and you two were standing there together, right?
Mm-hmm.
Okay. Do you know Miss Lee McMichael?
I do.
How do you know her?
Lee and I work for the same place, so in passing, just colleagues.
Same hospital?
Yes, sir.
All right. Y'all see each other in passing, talk about friends and family, live in the same neighborhood?
We don't usually chit chat, but we're friendly.
Okay. Friendly enough that y'all want to boat ride together?
Yes. So, right. Brooke and Diego invited me, and I'm not going to turn down a boat ride.
Fair enough. Fair enough. Did you know Mr. Arbery?
I did not.
Before this happened, did you ever hear about him?
Not by name.
You never heard that name before, right?
Correct.
None of your friends or family knew him?
No, sir.
The incident at your house where you said that you saw two guys with a flashlight, those are police officers, right?
Yes, sir.
Okay. You never saw any trespassers on your camera that night?
Correct.
You just saw the aftermath of people looking for somebody?
Right.
And in fact, you've never seen a trespasser on your camera ever?
Correct.
Did you ever view surveillance videos from anybody else's house personally?
Being so far after the fact, I don't know if the videos I saw were, just from the internet or anyone's phone. I mean, if I did, it would have been from Brooke's phone, but I don't know.
Your mom had her car broken into, right?
Yes, sir. Well, rummaged through. It was unlocked.
It was unlocked. We tend to use that term pretty loosely, right?
Yes, sir.
Door was unlocked, car went through. Still unnerving.
Very.
Nobody wants that to happen.
Right.
Didn't call 911?
No, I did not report it. And my mom was out of the country and asked why I didn't. And I'd seen on the Facebook page that someone's car was also, things were stolen. And when she did report it, the police were maybe a little flippant about it, just a car break-in, make sure you lock your door. So I thought, I'm not going to call the police for her car being rummaged through.
That seemed to be a trend in the neighborhood? That seemed to be a trend, people leaving their cars unlocked and things taken out?
I don't know if they were all unlocked or not. But you should still be able to leave your car unlocked and know your things are safe.
100%. 100%. It's not your fault. It's not anybody's fault.
Right.
Right. Since you've lived in Satilla Shores, you haven't personally witnessed any car break-ins, correct?
No.
You haven't witnessed personally any property crime?
Crime other than
property crime?
No.
Okay. You've never witnessed or heard about any physical assaults?
No.
Really, the only thing that was going on was this car break-ins.
Car break-ins and several reports of a person that no one knew kind of lurking around. My boys called one night when I was at a restaurant, and it was like 8:30, and they said,
Judge, I object to
"Oh,
this.
sorry."
Yeah, a non-responsive answer. Yeah, ask to strike that.
I would ask that you have the clear answer.
I asked about assaults, and then it went into something else.
Oh, really interesting. Yes. Move on. Can't remember whether you did or
Mentioned suspicious person.
Yeah,
no, it was not responsible.
it was non-responsive. As administrator of the Facebook page, you were able to see all the different types of theories about who might be doing this, right?
I had access to, didn't necessarily engage or read it actively.
Did you get alerts on your phone as the administrator from being a part of Satilla
I
Shores?
turned off my notifications from Facebook in general just because they get overwhelming at times.
Fair enough. Had you heard that people thought it might be teenagers?
I don't recall.
want to talk to you, Ms. Lawrence, about a time when you had a conversation with Travis McMichael after the shooting. Do you remember speaking with him in his driveway at some point after the shooting about this case?
No, sir. I remember he was coming home one night and I was out in the road and he just stopped and we talked.
And y'all talked about the case and what happened?
Right. Yes, sir.
Right. And he told you there was a video out there
Yes, sir.
and that him and his dad were planning on, quote unquote, leaking it.
Right.
And you agreed to help him do that.
Probably not at that time. And I didn't agree to leak it,
At some point, you and Travis had a conversation about,
that I would share it once it got out. Right.
and I think, if I'm not mistaken, it had to do with you helping get his version of what happened.
Right. The neighborhood's version of past events and yes, kind of all the things that led to this.
Because at this point, everybody had seen that video, right? Or a lot of the neighbors. You've seen it.
I have seen it, but I don't know about it.
They showed it to you. They showed it to you.
Correct.
On their phone or wherever they had it. At that point, nobody knew that they actually engaged in a full-on chase through the neighborhood. Correct?
I don't know.
You don't know?
I don't know what everyone knew.
So what I'm asking, what they told you. Did they ever tell you that they chased Mr. Arbery or followed him in a car, whatever you want to characterize it? They never told you that, correct?
I don't recall that.
But they, who be talking about?
Greg and Travis. Greg and Travis. They never told you they engaged in that chase, right?
Correct.
And you never heard from anybody else about that.
I'm sorry, one more question about what?
You never engaged with any sort of conversation with anybody else about a chase that occurred, correct?
Correct.
Yeah.
I didn't know there was a chase.
At some point after the homicide, and I don't know if it's before or after this conversation, Travis asked you to admit him into the Cecilia Facebook page under the name Travis Hacker. And it was a fake Facebook page, correct?
Correct. Because his actual Facebook page had been hacked.
But he didn't take the time to set up a new one under his real name.
I don't know that Facebook makes it that easy, but I don't know what he did.
Because he wanted to know what people were talking about
I was going to object to Kenrio asking with Travis McMichael believe.
This is a conversation. I'm asking about the conversation.
So I would ask that to clarify what makes it come from Foundation.
You and him talked about the purpose of him creating this Facebook page, correct?
Yes, sir.
And that purpose was from him to be able to monitor what was going on throughout the neighborhood under this fake name.
Monitor what was going on? I don't know.
Look at what people were saying.
Right.
At some point, the neighbors were, as you said, they post about maybe water that got shut off, complaints with things going on in the neighborhood, crime of some sort, right? That's kind of the general things that were being posted on the Facebook page, right? Okay. And at some point, there were strings of messages or posts about car break-ins that were happening. You remember all that?
Fair enough. Yes, sir.
Okay. And you engaged in some of those conversations, and at some point on January 30th, you posted about leaving your window down, and we're lucky nobody took your purse and wallet in the front seat.
Right.
Is that right?
Correct.
Okay. Bubba and Renee Herndon posted about their gun being stolen, right?
I don't recall.
Don't recall. At the very end of that, Travis posted, "They're playing with fire on this side of the neighborhood." Remember seeing that? He posted that?
I don't.
One minute. Okay. Ma'am, that's all I have.
Thank you. Ms. Lawrence, Mr. Camarillo asked you about the video that we've seen in this case regarding the shooting of Mr. Arbery. Remember that?
Yes, sir.
You mentioned that you were willing to share it. Right? Share it meaning the video.
Correct.
How are you going to share it?
Text or social media.
Post it somewhere?
Yes, sir.
Send it to friends or family? And why? Tell us why you were willing to share that video.
To me, I felt it matched the story that I knew to be true of this person lunging for the gun. And so this is the story I heard and have no reason not to believe. And so seeing the video kind of confirmed, okay, this matches the story and the video match. So you're lucky you have this on video.
Okay. And so you were willing to put it out because you believed it to be the truth?
Yes, sir.
And about what time of year was this? Do you remember?
Oh, I don't.
Was it after the media had gotten a hold of the story and was kind of blowing things up?
It was after the video was released and then didn't get a positive response.
Okay. All right. Did you ever share the video?
No.
Okay. But you were willing to?
Yes.
Okay. The Travis Hafner, I think, was that the name Mr. McMichael wanted to use?
I don't recall.
Okay. Tell us about that. What had happened prior to him approaching you as you understood it? Why he needed a new moniker on Facebook?
Someone had hacked into his account, and so I guess I don't know if they automatically shut it down or he had to shut it down, but it was just a way to get on Facebook.
Okay. And was this again after the national media had started reporting about the shooting of Mr. Arbery? Do you recall?
I believe it was after.
Okay. And as the administrator, what did you have to do to allow Mr. McMichael to?
I don't know that I actually did. I'm sure there's a record. I'm not saying I didn't, but it's just an easy approve or decline.
Okay. And tell the jury why you were willing to approve Mr. McMichael, Travis, being on the Facebook page under a different name.
I believed the account of the events as they transpired, as they were told to me by the family, and didn't see a reason he shouldn't have access to what people were thinking.
So it was to monitor what other people were saying about him? Is that as you understood it?
Or maybe not necessarily of him, but of the event in general.
Okay. Did you, as the administrator of the neighborhood Facebook page, see anything wrong with that?
No.
Was the name Travis Hafner or whatever name was used by Travis or anybody else to put out information about the case, to your knowledge?
I don't think he actually posted anything, but I don't
You don't
recall.
Okay. Just give me 1 second. Thank you, Ms. Lawrence. Appreciate it. That's all I had on.
Thank you. You may step down. Is she released? Yeah. She understands me. Then you can step down. You're released.
Your Honor, before the next step, we'd ask that the jury be asked to step out. We bring the matter up.
All right, ladies and gentlemen, let's go ahead and take a final 15-minute recess. All right.
Producing evidence on. So if this works, okay, we haven't actually worked this ballet out here, but if I could, the mental health evidence was prohibited by this court. But since that time, you now have testimony from Travis McMichael where there have been complete descriptions of behaviors and conclusions drawn from those behaviors by Travis McMichael that are consistent with a number of the things that were reported in the Gateway records and would have been corroborated and explained even further by Kelly Kaufman, who was our mental health expert. So I can do each of these, or I can lay out the new information that we asked the court to consider. Would you prefer that I go by each?
Well, once you get through it, then I'll try to address it in turn.
Here you go. Thank you, Your Honor. Second, we had also sought to introduce evidence that Ahmaud Arbery was on probation under 2 felony offenses. A great deal of exposure still left on those. The court denied that motion. I point out that in the state's case, the medical examiner was permitted to testify about fight or flight, and even after objection, was permitted to give his opinion concerning fight or flight and cortisol, etc., as being the explanation in his mind for, under the state's questioning, the decision to make a sharp left versus a sharp right out of the neighborhood. Number two, with respect to probation, under the cross-examination of Travis McMichael, he was cross-examined by Ms. Donikoski at several points for quite some time about in a way that indicated that the state's position found it to be incredulous that Ahmaud Arbery would just have run back at Travis McMichael at 2 different occasions, and then certainly that he would have directly run at Travis McMichael to engage in a behavior that is otherwise unreasonable. So for that reason, we would ask that the court reconsider and allow us to introduce evidence of Ahmaud Arbery's probationary status as further explanation for why fight or flight, while that is the state's theory for taking the sharp left and attacking Travis McMichael, may have been to avoid being apprehended by the police and, again, having to do time or face further investigation for his probationary status. And third, the use of force experts. We had asked for a use of force expert, primarily the Travis McMichael team, to explain to the jury the theories that Travis McMichael did a very good job explaining on his own. However, once he explained them, he was cross-examined by the state on the way that he implemented that training, and even at one point an exhibit from his training was placed on the Elmo, if that's what it's still called. I don't know if that's on the screen, on the screen for the jurors concerning some of the training and the ways that Travis McMichael would have made decisions on that training. Because he was cross-examined, I believe now the state has opened the door for the use of force expert and testimony to come in to provide the support necessary to corroborate his testimony for which he was cross-examined. So while we do need rulings on those 3, given this additional evidence in the state's case and the defense case, we also need to perfect the record for a more complete proffer as to what the mental health evidence would have been. The court is aware, because of the records that we submitted of Ahmaud Arbery's probationary status. I believe you have those records already. And then I need to just inquire of Travis McMichael's team as to whether the use of force expert testimony has been properly proffered as to what he would have said had he been allowed to testify, and his credentials.
The gateway records, you don't have to look. The gateway records were reviewed by the court and then sealed into the case.
Correct.
Okay.
Yes, I believe that is the case, Your Honor. And of course, there are a few other things that we're going to make sure are in the record that doesn't change much now and doesn't require us doing them before anybody rests. Some of the notes, I'm sorry.
For the record, we would join in the 3 issues that the McMichaels have raised before we move on to something else, if that's okay. All I would add, Your Honor, is maybe I missed it, and I certainly don't mean any criticism. I think I owe the court a few things, but I don't think I've seen or been served with a copy of the court's order on the probationary status ruling. And honestly, I was waiting for that so that I could move to reconsider. But it's hard for me to move to reconsider when I don't actually have the reasoning of the court on that. So I hope the court would allow me that opportunity in the morning, assuming that sometime before 9 a.m. the court enters an order on that. You orally indicated that you wouldn't allow it. You indicated that you would follow up with a written order, kind of like I promised I'd do a bunch of things, and I'm still working on those. It's not a criticism, but I was hoping to have the court's written order before being in a position where I had to either move to reconsider or waive the issue. So I'm not like joining in that, but I'm humbly asking the court if the court can. The court's under no obligation to enter a written order. But my understanding was the court gave us a short summary of its reasoning with the representation. It would follow up when it had the opportunity. Because the court hasn't had anything else to worry about during this trial. When the court had the opportunity, I would like the opportunity to move for the court to reconsider when I have that written ruling.
And I was through with those 3. I just want to let the court know that we will perfect the record with some of the other things we agreed to place under seal, one of the notice of filings, and then the Facebook records with respect to some of the cause strikes that we made. Y'all agreed to get those under seal. I just haven't gotten that done yet.
There are a number that probably go through at some point, make sure everybody's on the page with what those items are, just to make sure that the record is complete based on what everyone understands, either it has been or has been promised to be submitted. Okay.
Thank you, Ron.
Thank you, Judge. On the subject of evidence that we feel the court should reconsider before we have to decide whether the closing or not, the 404B evidence that we have submitted to the court, we heard a lot of testimony from uniformed officers. We heard testimony from a uniformed officer in a park setting where he approached to try to speak to Mr. Arbery about some suspicions that he had about Mr. Arbery and how that de-escalated into confrontation. We heard that it escalated into confrontation, excuse me. That officer was dressed in uniform with badge and gun in a marked patrol car, and that still happened. We have the encounter in Burke County where Mr. Arbery was chased out of an abandoned building where they suspected marijuana use. He was shouted at, told to stop running, come back. police by an officer in official clothing with badge, gun, police cars, and did not.
Well, wait a second. The submission of evidence, I mean, I think there were 10 separate incidents submitted, of which the court has addressed in the order, and we received evidence through hearing. That's all part of the record.
Okay.
So I understand what motion you're talking about.
Yeah. Thank you, Judge. So what we've seen then in the case, and the reason why we're asking the court to reconsider this evidence now, and we want to limit it to it wouldn't be all 10 things, it would be things that speak to this particular issue, which is the state has asked all law enforcement officers about their manner of dress, their clothing, and how they use that for presence and to talk to people and make arrests, and to try to, I think, distinguish what they did with Mr. McMichael, which is you were not in uniform, you did not have a badge, you were not in an official car, you didn't have any official looking presence. And they also questioned Mr. McMichael about Mr. Arbery has no obligation to stop and talk to you. He has no obligation to speak to you. He has no obligation to explain himself. He can run away from you, and you weren't wearing a uniform, a badge, etc. So this has made now relevant the fact that for Mr. Arbery, for Mr. Arbery in particular, when an individual approaches Mr. Arbery and questions him about his conduct, he doesn't engage in a typical fashion. He runs or he gets combative or confrontational, and we have evidence of that over the timeline which we've submitted to the court. The state has now presented this evidence to the jury through the questions and answers, and I guarantee you will argue it in closing that Travis McMichael, dressed as a plainclothes person, Mr. Arbery had no obligation, and thereby essentially create this chasm. The jury should be made aware about the 404B evidence for the purpose that it is limited for, which is to show motive and intent. They're going to get into his intent and have done so already by opening the door on several other occasions, talking about an opening statement being an avid runner, talking an opening statement about Nike shoes so worn that the tread was worn off, that he ran off on his jog toward the McMichael's house, that he never stole anything, he never took anything. Through Matt Albenzi, they questioned him, saying, you don't know why he was in the house, sort of baiting the witness. You don't know why Mr. Arbery ran, introducing the issue of his intent in the house or him running. They actually brought Kelly Parr to testify, and she even talked about his behavior and his intent and what he did not do, like ducking or hiding or running away, that he just stood there. Again, putting his conduct into the case. The 911 call, they allowed Larry English to testify that he looked like he was drunk or on drugs or disoriented. Officer Rash was allowed to testify that he was trying to figure out why he was coming there at night. That's what Rash testified to. Your intent, Officer Rash, was to identify him and find out why he was coming there late at night and then trespass him. Again, the state is putting in Mr. Arbery's intent through the officer, now trying to say, we're trying to actually figure out what his intent is there that night, making the intent issue relevant. And that Officer Rash took action throughout the entire neighborhood to find out why he was there, and riding around, asking people, do you know why he's here? They asked the question about, do you know of his routine? That was objected to and sustained, so that's not evidence. They tendered the photograph of the sneakers, the top and bottom. So all of these things are getting into Mr. Arbery's intent, Your Honor, and it goes beyond where the court wanted us to be, but this is all through the action of the state. And so we would say now that his intent has been put in through their opening statement, as well as their law enforcement officers and some neighborhood witnesses. Notice we didn't ask any of our witnesses, did you see him, did you know him, does he run in the neighborhood? We didn't ask that, but they did. And so for that reason, it reopens the door. It opens the door for 404B, and we would ask you to revisit it because of those things.
And Your Honor, I would join in that motion for reconsideration as I joined in the original motion. And I will add this. I don't understand how the state can be pursuing a theory of aggravated assault that's based on the fear of Mr. Arbery, which is going to his mental state at the time that he's being chased, without opening the door to any facts or circumstances that inform his mental process there. And we can certainly take that up at charge conference. That's been noted to the court. But I mean, if the state is pursuing an aggravated assault theory that is based solely on intent to injure, intent to assault, that's one thing. That's the mental state of the defendants in this case. If the state is pursuing an aggravated assault theory based on the reasonable fear of Mr. Arbery, then these other circumstances are certainly informing his decision as to what he's doing. I think the court should require the state to make an election as to what theory they're proceeding under before the court ultimately rules on the 404B issue. Having said that, as I said, I've joined in the motion.
Yes, Judge, the state asks that you deny these 4 motions for reconsideration on all of these issues. All of this was known before we ever started. The mental health is totally irrelevant. 401, 403, they didn't know Mr. Arbery. 404B evidence on Mr. Arbery, they didn't know Mr. Arbery. So therefore, the same rulings and orders you've entered apply right now, despite all the evidence that has been put up. There is absolutely nothing about his mental health, given that Travis McMichael didn't know about it. But Travis McMichael took the stand and told the jury his perceptions and what he thought about Mr. Arbery. So that evidence, based on his perceptions, is before the jury. Probation with fight or flight. Actually, at the end of Mr. Travis McMichael's statement, it was fight or flight. He actually said that. I assumed the defense was going to ask him about that, and then they didn't. Blaming the state for cross-examining their client is a bit of a ludicrous argument, because the state's position is Travis McMichael is lying, not that it's incredulous about Mr. Arbery, that Mr. Arbery would do this, Mr. Arbery would do that. What's incredulous is the lies Travis McMichael is trying to tell this jury, all the stuff he's come up with. That was what the cross-examination was about. The use of force, he got up here and talked about his use of force. He explained it. He did the continuum. Mr. Rubin had him talking all about it. To say the state, once again, cross-examined about it, so now we've opened up the...
Thank you.
You're absolutely right. It was Mr. Sheffield. But to blame the state and say, well, you cross-examined our client about what he's telling the jury about use of force, so we get to bolster his testimony now, we ask that you go ahead and deny that as well. And there is absolutely nothing that the state's done to talk about Mr. Arbery's intent. We talked about Officer Rash's intent as a law enforcement officer. That's what we talked about. The 911 call, they stipulated to the 911 call where Larry English goes, oh yeah, this is what he looks like out on the boat. And yet they're complaining. So, Your Honor, your orders that you entered on all four of these issues, your oral one on probation, we ask that you deny their motions for reconsideration based on the evidence that has been presented here. Thank you.
Any final word then?
Yeah, I stand on what we said. It's not an issue of blame. It's an issue of what proof came in that might inform the court in seeing this in a different light than you did before the evidence that you had an opportunity to see.
Before the court, then, our motions for reconsideration on the four evidentiary issues that were brought up. There is an existing order on the, I'll just refer to the gateway records. I don't have it right in front of me. I forgot how that was couched in order, but that was the character. I think it was actually the state's motion in limine on character, which then resulted in a number of filings. That existing order has been in place. Considering the motion for consideration, the court is not going to allow those records to come in. The probation and use of force expert orders will be to come. Those are in the process of being drafted. Mr. Goff, they will probably not be in a form that will get them filed by tomorrow morning. But what I tried to do, and I do remember doing, at least on the probation order, was lay out where the court's opinion was based and how the court reached the conclusion that it did based upon the evidence presented at trial. The court's not going to reopen either of those two matters. And then, as with the first issue, there is a written order on the 404B evidence, which are the various things Mr. Sheffield was just referencing. And again, the court on the motion for reconsideration relies upon that order and has considered the evidence referenced during trial and is not going to reopen that matter. So for the record, I think that should clear the record out. If there are matters that need to be placed into the record that have been referenced as being sealed into the record or need to get into the record, I'll keep the record open. I'll figure out the best time to do that until, which I understand then would be documentation that we have discussed before the court that just needs to be part of the file. I would imagine we'll keep that open probably through, I would imagine through closing, maybe to closing. If that's a problem, why don't everybody let me know what needs to come in and how long it's going to take to get it in. Maybe that's the way to do that. I'll keep the record open. Okay.
And at the appropriate time, I did have a couple other things to add.
You can share with the McMichaels.
Oh, I'm sorry, I'm not interrupting. I do think, in order to perfect the record, certainly on the use of force expert and perhaps Dr. Kaufman, that we would like the opportunity to call Rick Register, who's a former ATF agent, FLETC instructor on use of force, to make the proffer. I think. No, they didn't do a scientific examination, so there's no. But we do need to put in the record what he would have said had he been allowed to testify.
Okay, well, let's figure out. When are they available?
I can inquire tonight and get back to the court. I think Mr. Register is very flexible.
Dr. Kaufman's a different story. Object in with her, but I'll speak with her to get back to the court as well.
Yeah, I mean, I can't keep the record open forever.
No, we could do it this weekend or next week.
Anything then further from the McMichael defendants?
Yeah, no, we'll rest when the court comes through.
Mr. Goff.
Your Honor, I'm so sorry. I think for the record, we actually need to hear from Greg McMichael personally, just to make sure it's on the record.
It's on the record. We don't need to hear from him.
I guess I did hear from counsel for Travis McMichael, counsel for Greg McMichael. I understand you're adopting it. I think it had been placed in the record before. Well, it had been placed in the record before that Greg McMichael would be, I can't remember the language that was used, effectively adopting the defense. But if there was anything else that may come up, then that would be presented. So what I understand is there's not going to be any additional evidence presented on behalf of Greg McMichael.
Well, what we anticipate you would do, Your Honor, is when the Travis McMichael team rests, you would call on us and then we would make our announcement.
Yeah, that's just, I'm trying to make sure I can.
Right.
Yeah. And so then Greg McMichael will rest, as I understand it, and then it'll be to Mr. Ryan.
I'm so sorry, Your Honor, not to be really, really picky, but being an appellate, at this juncture in time, Greg McMichael has not stated on the record whether he's going to testify or not. And he has not put his decision on the record. So if the McMichaels rest, the problem is a clever appellate attorney is going to come behind and go, Mr. Greg McMichael never was giving out.
And that's fair, because as I think I'm usually used to defendants in the discussion with the court on testifying, saying whether they have or haven't. Actually, in this case, he hasn't said whether he intends to testify. It's my understanding that Mr. McMichael does not intend to testify and intends to rest.
Well, Your Honor, we'll announce that when you call on us to present our case, but yesterday, I believe it was, he made the full and proper inquiry about whether he understood his rights.
I think we might be talking in circles. I think we're all in the same place.
I think we are.
Okay. Understanding how I think this is going to work, then we will get to Mr. Bryan's case in chief today. Okay. I'm sorry?
Sure.
Yes. All right, let's take a 10-minute recess, and we'll go ahead and get the announcements on the record in just a moment, Mr. Collins.
Okay. I had something I wanted to bring up. I can do that after the recess.
We're all here.
Your Honor, I would note again, it brought to my attention over the last break, that we have a potpourri of political statements parading out in the foyer in front of this courtroom. And again, we don't understand how this First Amendment activity, which is prejudicial to our client's case, continues to happen inside the courthouse. I'm not picking on anybody, but it continues to take place. We had a huge protest. When I had access to a color printer, I'll print out some exhibits. We had a huge protest at lunchtime that was so loud with bullhorns, literally 20 feet from the front door of this courthouse, that you could hear what was being said at the doors of this courtroom within the facility. And again, that all goes back to our concern about the fair trial. But the most pressing concern I have is, because I can't read the minds of other counsel in this case, is my assumption is that there's one more witness yet to come, but based on the last couple witnesses, Your Honor, it's not for me to make an objection to character evidence presented against a co-defendant. That's an issue for other counsel to deal with if they think there is an issue. But I heard testimony today, for lack of a better characterization, as vigilante social media posts or communications involving co-defendants. And then, we have this after-the-fact conspiracy evidence coming out from the last witness. I believe that was Susie Lawrence, talking about her talking to the McMichael defendants, or one of the defendants, about the famous video in this case. I felt under 403 it was more prejudicial than probative in the case, but technically that evidence as presented didn't directly refer to my client, although you could put things together as to where this famous video is coming from. But we're right at the precipice of getting into and establishing or suggesting an after-the-fact conspiracy involving my client. And that's going to raise some serious severance concerns, because now my client is going to trial with two Dirty Harry style vigilantes, if I understand the import of these of the post. And we now have this after-the-fact conspiracy, which the state has cleverly found a way to get right up to the precipice without actually implicating my client in it. And again, that's going to put us in a severance posture. And if I'm right, the next witness that the McMichael defendants are calling, I suspect we're going to get into more of the same. And if, in fact, the state has intentions of going into any more after-the-fact conspiracy evidence or vigilante evidence in this case, then I think that the court should address what they intend to go into before they do it, and not make me stand up and object in the presence of the jury. Because I'm just not as fluid as some of the other people in this case with these 803s and 403s, and heaven forbid I would make a speaking objection in front of the jury that the state might find objectionable or the court might find objectionable. So if the state intends to go down that path with the next witness, then I think we need to take that up outside the presence of the jury before their cross-examination.
If I knew who the next witness was, I might be able to address this.
I am not aware of the relief the defendant is seeking. That was a broad brush, Mr. Goff.
It was.
So I guess we are noting it for the record.
We are noting the severance issue for the record, and to be more specific, if the defense, I don't know what they're doing, but if the defense is going to call Diego Perez, who I had thought the state was calling, but they decided not to call. I had thought the defense was calling. Maybe they're not calling, but if they're going to put him up and the state's going to backdoor in vigilante issues involving the co-defendants or after the fact conspiracies, before the state does that on cross-examination, I think we need to take that up outside the presence of the jury.
Well, the court will take that matter, I think take the matter under advisement. Duly noted. Let's go ahead and take it to no recess.
Golf he makes my blood pressure rise. I'm not telling stories. He really do makes my blood pressure rise. Like, God, that's the tone of his voice, everything about it drives me.
Graced us with his presence in public gallery this afternoon. The third. I'm sorry. The third. Martin Luther King the third. Martin Luther King the third. Yeah.
Apparently, the state does not look like he's in the gallery now, so I think the state's wanted. The state has its back to the public gallery, so I imagine they wouldn't know. All right, thank you. I think the statement.
I think just want to note that George Will was wide awake and paying lots and lots of attention this afternoon to the gifts.
Sure, number 12 has been engaged, and I've been watching her. She has moved, looks like permanently, closer to the bailiff on her own volition, and that seems to be working. All right, let's go get the film.
All right for the jury. Please state it.
All right, welcome back, ladies and gentlemen. We are ready to proceed with the case from Travis McMichael.
Your Honor, on behalf of Travis McMichael, we rest.
Thank you, Your Honor.
Greg McMichael.
Your Honor, on behalf of Greg McMichael, we rest.
On behalf of Mr. Bryan.
On behalf of Mr. Bryan, we've discussed this with the state. Rather than being compelled to republish the Night Owl porch video, still picture of Mr. Bryan's residence, republished Night Owl 2 video with the trucks, and rather than publishing this excerpts from the state exhibits of investigator Officer Minshew and Detective Lowry, the state has agreed that we don't need to republish those today since we went through that yesterday. Reserve the right to do that during closing statements.
I'm sure that's been discussed with the state.
It has, Your Honor.
With that understanding, we rest.
Anything in rebuttal from the state?
No, Your Honor, nothing in rebuttal.
All right, ladies and gentlemen, what that means is that all of the evidence that will be presented in this case has been presented. So let me tell you how we're going to proceed from here. There are matters that the court's going to need to address. That's going to take a little bit of time. We are going to go ahead and adjourn until Monday morning at 9 o'clock. Okay, so you are not going to be required to be in court tomorrow, but you are going to be required to be here at 9 o'clock Monday morning. Now, over this period of time, done. Well, before I do that, let me just go around. Anything from the state before we start?
No, Your Honor.
From Travis McMichael. From Greg McMichael.
We're ready, except I have one thing printing, if you would allow me to grab it, if the printer was a little louder.
Okay. And from Mr. Brown.
Thank you.
We're ready, Your Honor.
Just got so excited to get into the charge, I forgot to go around. Sure. All right, get everybody back. All right, so I mentioned to council that what I have done to this point is I have the request to charge submitted by the state. I've got Mr. Bryan's first request to charge. There's an additional request to charge from Mr. Bryan and the defendant's first request to charge, McMichael defendants, I should say. What we did is I took those requests and put them all together in one large document just to see where there was duplication on the charges. And then based on that draft, I narrowed down into the draft you received last night, what I'm calling draft number 2, which is really just a clean copy. I've taken in places where, say, there were 3 different requests on the same issue, I have put in the draft charge you received last night what I distilled down into an appropriate, or what the court believes is an appropriate charge. I realize that this does not include all of the charges that have been requested. This obviously is everybody's opportunity to raise whatever issues you have with respect to the charge the court has picked. And we'll go ahead and discuss those on the record. In the draft you received last night, there's also some, I'm not sure how it came through as highlighting or gray, but there you'll see there's some highlighting in that in there. Most of that is the headings.
I probably should mute before I unmute before I do that. But real quick, Telegang, are y'all good with just skipping to closing arguments since that's where we are? Or do you guys want to sit through any rulings that are made over the verbiage and stuff? Because I'm cool with just skipping the closing arguments and getting it out the way and being ready. Let me know in the comment. All right, Star wants to skip. All right, Bernicia said skip, so that's what we're doing. That's what we're gonna do. We're gonna skip to okay, so they may not have done closing on day 12. Okay, closing arguments begin.
Any of those issues?
Here we go.
Submitted by Mr. Bryan, which is a civil charge about liability. It says, where a reasonable man would investigate further before instigating a prosecution or making an arrest, he may be liable for failure to do so. And I don't know that the jury will even understand why that's in there, because it's about liability. It's on page
16.
Yeah, 16.
Let me go further around the room and from Greg McMichael.
Yeah, we adopt Mr. Rubin's argument just now on page 15. Excuse me, the section concerning the requirement that an arrest be made contemporaneously. While we think that wording is greatly improved over the request.
Feelings about the delay, if any, were excused by the court for cause. Those jurors said that they could be fair and impartial, or the jurors we have seated here making up the jury for this case. Also, the court has instructed the jury to stay away from the news media on this case, and we've seen no evidence that they've actually not been able to follow that law. There's absolutely no evidence that they went and saw the AJC article that Mr. Goff is talking about. Therefore, we don't believe he's made a clear showing of prejudice in bullets 1 through 5. As far as bullets 6 through 7, the only evidence of Greg McMichael's ties to the Glynn County Police Department is that maybe a few of the officers, I believe Detective Lowry testified that he knew Greg McMichael in passing. Detective Parker Marcy also, I believe he testified that he knew of him, but they didn't have any close relationships with Greg McMichael that would tend to show any reason for a cover-up. Also, notably, Jackie Johnson's name was never ever mentioned in the presentation of evidence in this case, Judge. Mr. Goff is the only person who keeps bringing up her name. We have not elicited any evidence of a cover-up. We don't intend to argue any cover-up because it would be unsupported by the evidence. So here he's made no showing of clear prejudice to his client. As to bullet 8, the evidence showed that Greg McMichael and William Bryan knew each other, but they didn't know each other very well. Actually, Mr. Bryan didn't even know Greg McMichael had a son named Travis McMichael. Travis McMichael testified that he never met William Bryan, and there was no express agreement between the McMichaels and Mr. Bryan. There was evidence presented that Mr. Bryan and Greg McMichael were talking to one another right after the homicide happened and during the time when the officers got on scene. But this evidence, even if he were to get a separate trial, would still be admissible in his separate trial. So for those reasons, we don't believe there's been a clear showing of prejudice here either as to bullet 8. As to bullet 9, this court is going to charge the jury as to criminal trespass, burglary, hijacking a motor vehicle as Mr. Goff asked for. And it'll be up to the jury to determine what, if any, crime the alleged victim committed in this case, Your Honor. The McMichaels actually never asked for the criminal trespass instruction. I believe the state is the one who asked for that instruction. And if Mr. Bryan were to go to trial separately, we would likewise ask for that instruction in his separate trial as well. So given that, we don't believe a severance is necessary here. Regarding the different accounts from Travis McMichael and William Bryan, Travis McMichael's testimony, we would argue, actually helps Mr. Bryan because he got up there and said he saw Mr. Bryan being attacked by the victim, his car being attacked by the victim. And then he also said, hey, there was no conspiracy between us. We did not have an express agreement. So rather than hurt his client, we believe that Travis McMichael's testimony actually helps his client. For those reasons, Judge, we don't believe clear prejudice has been shown here. As far as bullets 10 through 11 are concerned, I want to point the court to Strozier v. State. It's 277 Georgia 78. It's a 2003 case. There, the defendant asserted that the evidence against the co-defendant was so overwhelming compared to the amount of evidence against him that it had a spillover effect on the jury. Essentially, that's what Mr. Goff is arguing here. And the court there held that, quote, the fact that the evidence as to one of the two co-defendants is stronger does not demand a finding that the denial of severance motion is an abuse of discretion, where there is evidence showing that the defendants acted in concert. And here, the state's theory of the case is that all these defendants acted as parties to the crime. So we believe that based on the holding in Strozier v. State, that no severance is warranted here either. As to the final bullet points, bullets 12 through 14, I want to direct the court to Swain v. State, 275 Georgia 150. It's a 2002 case where the defendant argued that the fact that the jury was jointly selected with the co-defendant denied him his right to a fair and impartial jury. And in this regard, he argued that the jury was not fair and impartial because a jury chosen by two defendants would be different from a jury chosen by one defendant. And there, the court held that the mere fact that a jury chosen by two defendants would differ from a jury chosen by one defendant does not deny a defendant a fair and impartial jury. If it did, then joint trials would effectively be prohibited, as a joint trial would deny a defendant a fair and impartial jury under the defendant's rationale, since defendants are required to share peremptory strikes in selecting the jury. So, Judge, just to sum up, no showing of antagonistic defenses, no showing that the spillover effect would prejudice Mr. Bryan to the point where it would be a denial of due process. We ask the court to deny the motion to sever.
Final word from the mayor.
Your Honor, I think the grounds are covered in the written motion. I would note that in response to the McMichael's request to remove the charge I submitted on duty to inquire, we would go ahead and withdraw that charge on our own. That would resolve the issue. I hope that will satisfy the McMichael defendants.
Sounds good.
I guess sometimes they don't want help.
All right, let me look at it. I'll have to look at it right now. Before I get to that, I also have a fourth motion to prohibit any further conduct that may intimidate or influence jurors or otherwise interfere with defendant Bryan receiving fair trial, a motion to excuse or inquire further as to juror number 380. The court has looked at it. I think the matter has been addressed a number of times. The motion itself addresses the issues presented by defendant Bryan. The court intends to deny that motion.
The only thing I would ask, Your Honor, is exhibits 7 to 11 are sensitive enough that I wouldn't want them in the public record with respect to the anonymity of our juror. That's we're able to preserve it. I'm going to show these to the state, but I'm going to ask the court place exhibits 7 to 11 under seal to preserve the privacy of juror 380.
I think the other defendants probably need to see the matters before they're placed under seal.
I'm placing those exhibits back in the manila envelope that is marked exhibits 7 to 11. Probably should have left them out before I did that.
For the time being, I'm just going to attach them to the back side of the motion.
Yes, sir.
And we'll go ahead and put a seal on there. I understand the state has no objection to sealing these. I guess I should probably take a look to do that. Those exhibits will be filed under seal. The duty to inquire language, the court's going to remove that from the charge. It's a civil case. My research also went on. There's some additional language in there that probably, if we start getting into it. So what I also have is, in addition to that language, which was specifically requested by Defendant Ryan, some additional language could also be that the defense not necessarily required to verify the information if it appears to be reliable, but, and it goes on from there. So I think with that language in there and it being primarily based on a civil case, I'm going to go ahead and remove it. I don't think it's necessary for this charge. So that is the only change the court is making from the draft charge. That again is the citizen's arrest duty to inquire on page 16. That one sentence being removed. All right. With that, is the state ready to proceed?
Yes, Your Honor, state ready.
All right. Welcome back, everybody. Hopefully, with a long weekend, at least from court duties, y'all are back well rested and ready to go. As I indicated on Thursday, we would be ready to go ahead with closing arguments in the case here Monday morning. We are ready to do that. I understand the state is ready to proceed.
Yes, Judge.
All right, from the state.
Thank you, Your Honor. Once again, ladies and gentlemen, my name is Linda Donikoski. I, along with Larissa Olivier and Paul Camarillo, represent the people of the state of Georgia and the citizens of Glenn County. Today, you are Glenn County. So why we're here is to go ahead and present you with the state's closing argument. Now, the state gets to go first and last because the state has the burden of proof to prove this to you beyond a reasonable doubt. But not just to prove to you beyond a reasonable doubt the charges in the indictment, but remember from voir dire, you were asked, can you give meaningful consideration to the defenses presented by the defense if they put any up? Okay, and what we've heard is what? Self-defense and citizen's arrest, which the state has to disprove beyond a reasonable doubt to you as well. So ladies and gentlemen, what the state's going to do right now is we're going to go through I'm going to give you a snapshot, that kind of like, here it is in a nutshell sort of thing. And then I'm going to take you kind of through systematically, piece by piece, what the law is as it regards to charges in the indictment, self-defense, and citizen's arrest. All right. But the one thing I want to tell you before we got started is this. You will have a copy of the indictment with you in the back. Okay. So you don't have to write down the charges in the indictment. You have a copy in the back. In addition, Judge Walmsley is going to give you a copy of the law. Okay. So you'll have a copy. So when I put the law up here, you don't have to furiously write it down. You will have a copy of it back here with you. All right. So let's go ahead and get started. This case is really about assumptions and driveway decisions. Now, you heard the defense talk about, well, probable cause. You're going to have to distinguish between assumptions based on gossip and rumor and all this neighborhood talk on Facebook and actual probable cause to believe a crime had been committed and someone had committed that crime. The state's position is all three of these defendants made assumptions about what was going on that day, and they made their decision to attack Ahmaud Arbery in their driveways because he was a black man running down the street. So here's what we got. The bottom line. They assumed he must have committed some crime that day because he's running real fast down the street, right? They did not call 911. They wanted to stop him and question him before they called 911. How do we know? Because that's what they told the police that night. That's what they said on the scene. Hey, stop, we want to talk to you. Can't do that. They made these decisions in their driveways. So what's really going on here? You know what's really going on here? Mr. Arbery was under attack. They committed 4 felonies against him. And those are the 4 felonies in the indictment. Then they shot and killed him, not because he was a threat to them, but because he wouldn't stop and talk to them. And they were going to make him, absolutely make him stop. We're going to point a shotgun at you. That'll make you stop. That should make you stop right here in your tracks because we want to talk to you. And what did he do? He still ran away. Still ran away. For 5 minutes, ran away. Travis McMichael went to intercept him with that shotgun, and he turned that corner. We can't see whether Mr. Arbery attacked him or grabbed the shotgun or anything. It doesn't matter. Because how fast did he shoot him? How fast did he just pull that trigger? They shot and killed Ahmaud Arbery. They all acted as a party to the crime. You'll note they've been indicted that way. And I'm going to talk about what party to a crime is so that you understand that concept. But the bottom line is, but for their actions, but for their decisions, but for their choices, Ahmaud Arbery would be alive. And that's why they've been indicted with murder, felony murder, and the 4 felonies that led to the murder. So what is the defense? I mean, I'm just going to take it right down there. We talked about that. What is the defense? We got self-defense. What is that? Well, they're going to try and convince you that Ahmaud Arbery was the attacker, that he was somehow threatening to them. 3-on-1, 2 pickup trucks, 2 guns. Mr. Arbery, nothing in his pockets. Not a cell phone, not a gun, not an ID. They want you to believe that he is the danger to them. And Mr. Rubin said it in the opening statement. He was scary. So here's the thing. They're going to try to claim that they were justified in their actions. Okay? Because here's the thing, ladies and gentlemen. You cannot claim self-defense under certain circumstances. You can't. You don't get to say I was acting in self-defense. And there's 3 of them. And it's the law. This isn't just something made up. There's 3 of them in the law. Okay? If you are the initial unjustified aggressor, you don't get to claim self-defense. If you're committing a felony against somebody, you don't get to claim self-defense. And the third one is if you provoke somebody so that they defend themselves against you. And then you go, oh, look, he attacked me first. But you really were the one who was provoking the attack on yourself. You don't get to claim self-defense. And that's the law. So here's the problem. They're going to try and claim they were justified in starting this in their driveways. They're going to try and claim they were justified in committing all these felonies against Mr. Arbery. How? Because they're going to try and convince you that this was a citizen's arrest. That's what they're going to do. But here is what a citizen's arrest really is. Okay? This is what the law says. This is the statute, and the judge is going to give it to you. A private person may arrest an offender if the offense is committed in his presence. Right here, right now, I'm seeing you do it. Okay? Right here, right now, I'm watching you commit the crime. I'm witnessing it. You're doing it in my presence. So what's the problem for the defendants? Well, we all know that Mr. Bryan's on his porch fixing it. Where's Travis McMichael? He's on the sofa inside the house. Where's Greg McMichael? This all started when I saw him running down the street. Now, it also says within his immediate knowledge. Well, the judge is going to charge you that that's synonymous. It means the same thing. So you got to think about, well, in my immediate knowledge, what does that mean? Think about the eye in the sky, at Walmart. Like you're in Walmart, right? And you see all those things in the ceiling. There's a guy in a booth watching a bunch of video cameras, right? So he's not standing next to the person shoplifting, right? When she shoplifts, right? What's he doing? He's watching it on the camera. That's immediate knowledge. He's not right there next to the person shoplifting, but he's watching it. So he has immediate knowledge because he can see it eye in the sky. That's just an example, how to think of immediate knowledge. But immediate knowledge and in your presence is the exact same thing. In order to make an arrest of an offender, the offense has to be committed in the private citizen's presence. Do we have that here? No. In addition, you will be charged, this is the second line, if the offense is a felony. So once again, the offense has to be a felony. The judge is going to charge you. Criminal trespass and loitering and prowling are misdemeanors. Okay? I'm going to pause right now. I'm going to ask you to read the criminal trespass thing. In order to be a criminal trespasser, you have to enter on the property with the intent to do an unlawful act, or somebody has to have told you can't come back here, like Larry English or his representative. Well, Mr. Arbery was never told, don't come back here. You're not allowed. This is private property. He was never told, so he doesn't fall under criminal trespass. Now, I don't want you guys to make the mistake of thinking that we're endorsing, or not acknowledging what Mr. Arbery was doing. I mean, let's get real. All right, what was Mr. Arbery doing? He's going on to somebody else's private property. Yeah. What was he doing? We can see it. Wandering around for a few minutes each time. Right? And then what would he do? He'd leave. On video, never took anything, never damaged anything. So, ladies and gentlemen, you decide. Is he this giant burglar who just happened to never show up with a bag or any means to steal anything? All right? Or is he a looky-loo? Yeah, a looky-loo who's going in there at night. He shouldn't be doing that. I mean, we all know this, okay? But it's trespass. It's a misdemeanor. And on February 23rd, 2020, none of the defendants knew that he had been inside in broad daylight, that location. And what did he do on the 23rd of February? Did the same thing he always did. Wandered around, and then left and ran off down the street. But they didn't know that. They had no immediate knowledge of that. It wasn't in their presence. Travis McMichael was on the couch. Mr. Bryan's in front of his house. Greg McMichael, you saw it. He can't even see down the road. There's that trailer there. Remember the drone video? Citizen's arrest. This was not a citizen's arrest. Not present when any crime was committed. The suggestion that Ahmaud committed a crime is based on what? Not immediate knowledge, speculation. Speculation. How do we know? Because the defendant's own words to the police, that's how we know. Wanting to question Ahmaud demonstrates uncertainty. Hey, where are you coming from? They don't know where he's coming from. What are you doing? They don't know what he's doing. Remember Mr. Bryan heard, what'd you steal? Okay, they don't know what he's done. They don't know why he's out there running. They don't have immediate knowledge. They have no knowledge. They have speculation because he's running down the street. Wanting to question Ahmaud demonstrates a lack of immediate knowledge, which is required under the citizen's arrest law. Because it's required, that means this was not a lawful citizen's arrest. Remember what Greg McMichael said? Did this guy break into this house today? I don't know. But hey, law enforcement officers, I'm sure he must have committed some crime today, so why don't you go out and figure out what crime it was that he must have committed today? Why do they think he must have committed something? Because he's running down the street. He might have gone into somebody's house. Pure speculation. And after he's lying there dead, Greg McMichael's there telling the police, hey, why didn't you investigate? Because I'm sure he committed some crime today. That's not a citizen's arrest. Not legitimate at all. So what are you going to hear?
I hate to interrupt closing argument, but the state is misstating the citizen's arrest law repeatedly in this section of its argument. And I'd like the court to instruct the jury that the law will come from the court. This is not an accurate statement of it.
The court is going to charge the jury on the law, and as indicated, you'll have a copy of that charge with you to review during your deliberations.
Thank you. Judge is going to charge you these exact words. Judge is going to charge you these exact words. So what are you going to hear? The state suspects that what you're going to hear from the defense is this, that Travis McMichael had probable cause to believe that Ahmaud stole the stuff off the English's boat in 2019 and was escaping that felony on February 23rd, 2020. Not really sure how you escape on February 23rd, 2020 from a crime you supposedly committed on some unknown date in 2019 that Travis McMichael's mom told him about. But basically, we have this where he came in, took a stand, and said, yeah, that's what was going on. So I was going to go ahead and arrest him for this. Here's the problem. This was completely made up for trial because no one anywhere at any time ever mentioned Larry English's boat. Never. On February 23rd, 2020. Travis McMichael had 2 hours and 45 minutes to talk to the police. He was given an hour to write a 3-page statement. An hour to write it down. Never, ever, ever once said anything about this. So what can you go ahead and assume? A year and 9 months later. Completely made up for trial. All right, so simply put, ladies and gentlemen, if you determine that this was not a citizen's arrest, this was not legitimate, he had no probable cause, you can't do this based on the law, then guess what? They're not justified in killing him. They're not justified in any of the felonies they committed against him. Not a citizen's arrest. Therefore, you're not justified. You're the initial aggressor. You're committing felonies. Self-defense. And that gets us to the charges in the indictment. So that's what we're looking at here. Based on that, at that point, you may find him guilty of all the charges in the indictment. All right, ladies and gentlemen, that was the snapshot view of what I think you're probably going to hear from the defense and what the state's position is on that. So now we're going to do some deep diving. What we're going to do is we're going to talk about the juror's duty. We're going to talk about some legal concepts that you need to be aware of. The judge is going to charge you. We're going to go over the charges in the indictment. We're going to talk about party to the crime. And then we're going to kind of really get into what self-defense and citizen's arrest is. And I know it's going to take a minute. Bear with me, but This burden's on the state. So we have to go through all of these things. All right, so here we go. Juror's duty. First off, this is your search for the truth, okay? This isn't about the state. This is your search for the truth. You are Glenn County. You decide whether they're guilty or not guilty. Not the defense attorneys, not the state, you, your search for the truth. You determine what really happened based on the evidence presented, okay? And ladies and gentlemen, I'm gonna go ahead and tell you right now, what's the evidence presented? Well, you can go ahead and look at State's Exhibit 190, which was the actual video. 191 is the half-speed video. You can take a look at State's Exhibit 194, the night owl video. You can go ahead and take a look at 129. That's that close-up compressed, sort of enhanced for coloration video that was produced that shows the close-up of Travis pulling that shotgun up. You can go ahead and take a look at State's Exhibit 117, Officer Rash's video. You can also take a look at 124, the video from December 17th, 2019. And of course, you can always ask to see State's Exhibit 315, the frame by frame, if you want to see it. So how that works is you send a note to Judge Wamsley and you go, we'd like to go ahead and review that evidence, and you come into the courtroom. When you come into the courtroom, we don't get to say anything, okay? Nobody gets to talk. And actually, at that point in time, you're in control of what you get to watch here in the courtroom. So I want you to be aware of that in case you want to review any of this evidence. All right, you are the finder of fact, not the state, not the defense. You are the finder of fact. You determine witness credibility. All right, you're the one who decides whether you believe these witnesses or don't believe these witnesses, or how much weight you give a witness's testimony. You're going to apply the law that the judge gives you to those facts as you find them to be, and that's what you're going to do. So you have a duty to follow the law. You're bound by the instructions and the law that the judge gave you. In other words, this isn't about becoming an advocate for one side or the other. This is about what are the facts, and here's the law, and we apply the law to the facts. You have a duty to deliberate. Okay. The reason I put this slide up is because one time we had a woman who went and hid in the bathroom for like an hour and a half. Like hid in the bathroom. And the jurors didn't know what to do. They were just sitting back there for an hour and a half and had no idea what to do. Anything like that happens, just send the judge a note. Okay? Anything weird happens, anything you're unsure of happens, send the judge a note. But you have this duty to deliberate, to talk about the case. Now, sometimes it's helpful to think about what's inside the circle and what's outside the circle. Okay? Because there's some things outside the circle that you're not, or shouldn't really talk about. And what are those? Well, that mostly concerns penalty and punishment. Ladies and gentlemen, you're going to be given a verdict form, and on that form, you're going to write not guilty or guilty. That's all you're going to do. Okay? So it's not about passion or prejudice, or you disagree with the law, you don't like the law, conjecture. It's about the evidence. And so what do you consider? Well, you consider the elements of the crimes. Judge Wamsley is going to give you that. The law, the expert testimony, okay? Fingerprints, fibers, the medical examiner, the photos and documents. Look at the crime scene photos. Take a look at those photos. They're hard, but take a look at them. The testimony of the witnesses, the credibility of witnesses, the defendant's actions, their driveway decisions, and how it led to someone lying dead from 2 gunshot wounds in the middle of the street. The elements of the offenses, the reasonableness, and above all, use your common sense. This is the time when you put on that critical thinking cap, okay? Meaning you question everything. It's sometimes really easy to see somebody and you want just to go, well, I want to believe what they had to say. You know, I don't want to believe automatically that they're a liar or anything like that. I want to kind of give them the benefit of the doubt. This is the time, ladies and gentlemen, that you put on that critical thinking cap, where you go ahead and scrutinize everything the people on the stand said to you. So, reasonable doubt. That's the doubt of a fair-minded and impartial juror honestly seeking the truth. It's not about seeking out doubt. It's about seeking the truth. And it's not beyond all doubt or to a mathematical certainty. No. It's just beyond a reasonable doubt. That's the burden that the state has. All right, so the evidence. The first thing you're going to want to do is determine what really happened based on the evidence, but a lot of the evidence isn't in dispute, right? I mean, we know what days Larry English called the police. We know when we have videos. We know this was on February 23rd. The homicide's on video for the most part. Okay, a lot of these things are not necessarily in dispute. What's in dispute is, were they making a citizen's arrest so that they were justified in committing these felonies against Ahmaud Arbery and then murdering him? I mean, that's really what they're arguing about here. So remember, it's not a gun. Glenn County Police arrived very quickly afterwards. Minshew heard the shots. The defense all made statements at the scene immediately after. They're making statements. They're saying stuff to the police. Then, a couple hours later, the defendants are all down at the Glenn County Police Department also making statements. But here's the thing. You've got to ask yourself, were these self-serving statements? I mean, think about it. The very first thing that we showed you was Duggan's body cam video. It was hard, right? But you got to realize, Travis and Michael seen him right behind Duggan when he rolled Mr. Arbery over. That's what he saw. That's what Greg and Michael and Mr. Bryan saw. So then you got to think to yourself, Okay, what's going on in their heads? There's a dead man in the street. Travis McMichael has just shot him. Okay? The police are on the scene. There's now a video of it. So are there statements a couple hours later, self-serving? You decide. The GBI did their investigation starting on May 5th, 2020, followed by the arrests. So first off, the credibility of witnesses. That's for you to determine who you believe and who you don't believe. Okay, so what does that mean is you're the one who decides whether Travis McMichael was telling you the truth or lying to you. Right? So let's talk about some of the defense witnesses. Annabelle Beasley, what did she do when she got off the stand? She walked over here and waved at them as she walked off the stand. I mean, I know you all saw that, right? Okay, so Annabelle Beasley, Team McMichael. Subi Lawrence, who is she? Boy, Team McMichael. Even after this, I mean, after the shooting, she and Brooke Perez and Diego Perez, they're going out in the boat with Greg and Lee McMichael. They're still hanging out with them. Okay, Team McMichael. Brooke Perez, Team McMichael. Up until February 11th. And then what did she tell you? Her husband, Diego Perez, had it with this. Had it with Larry English, not calling the police. Had it with helping out Larry English. He wasn't going to do it anymore because this was not cool. Why was it not cool? Because Diego Perez went inside that house with his flashlight. And Greg McMichael came up and went in the house. What was Brooke doing? My husband's in there. My husband's in there. All right. Well, Greg McMichael had his gun. Travis McMichael told you that. He had his gun. Diego had his gun. Brooke had her gun. You know, everybody had a gun. Everybody in this case had a gun except Ahmaud Arbery. And so what almost happened? I mean, come on, let's get real. It's a miracle Diego Perez and Greg McMichael didn't kill each other inside that house, right? Pulling guns out. And that was it. What did Brooke tell you? No more. Not doing this anymore. You determine the credibility of those witnesses. Now, when you consider Travis McMichael and his testimony, here's some things you want to look at. The judge is going to tell you these are things you consider. The manner of testifying. Evidence of bias for or against a party. Does he have bias for or against Greg McMichael? It's his dad. Okay? Motive in testifying. Yeah. He wants you to come back with a not guilty verdict. It's in his best interest. Think about the probability or improbability of their testimony. I wondered why he was attacking that truck. But on Holmes, what are you talking about? I have no idea. I mean, do you guys understand what he was getting at? I mean, I guess we're back to Ahmaud Arbery's a carjacker. Their interest or lack of interest in the outcome of the case, meaning do they have something to gain or lose by coming in here and making up a story for you? Their personal credibility as you observe it. That's for you to decide. Not for the state to decide, not for the defense to decide, for you to decide. All right, so did Travis McMichael have a motive to lie to you? Did he have a motive to make up additional things that he had never said before? All right, did he have a motive to embellish his testimony? Did he have a motive to claim he now is confused on February 23rd, 2020? Isn't that convenient? Wow, it was the most traumatic, yeah, and I don't dispute that it was probably the most traumatic experience of his life. How did Mr. Arbery's day go for him? All right, most traumatic experience for Travis McMichael. So he's all confused, but did manage to write out a 3-page statement and immediately put down on January 1st, my gun was stolen. Had all sorts of contextual details in that statement. Did he have a motive to use talking points? Okay, well, ladies and gentlemen, did he come up here? How many times did he say totality of the circumstances to you? Did he have his talking points down a year and 9 months later? That's for you to decide. The defendant's story. The law allows you to disregard his testimony from the witness stand if you don't find it credible. The law allows you to consider as the actual real evidence his actions at the time of the murder if you don't find him credible. Intent to commit a crime. Well, ladies and gentlemen, you got to find that they intended to commit these crimes. And how do you look at that? Well, you look at the natural and necessary consequences of the act, right? Natural and necessary consequences of an act. Deadly force is the last resort. Never point a gun at someone you do not intend to shoot. So when you start pointing a shotgun directly at somebody, what's your intention? The natural and necessary consequence of the act. You're going to kill this person. You're pointing it at. The defendant's not going to be presumed to have acted with criminal intent, but you may find intention or the absence of intention upon consideration of their words, their conduct. What did they do out there? Their demeanor, their motive, and other circumstances. So when you look at each defendant separately, because that's what you're going to do, you're going to get 3 separate verdict forms. When you look at Mr. Bryan, what were his words? What was his conduct? What's his motive? What were the circumstances there for Mr. Bryan? What were they for Greg McMichael? What were they for Travis McMichael? All right, so what we're going to do now is we're going to talk about the charges in the indictment. All right, I'm going to make a suggestion to you. This may help you. Start at the bottom of the indictment. all right, in your deliberations, start with criminal attempt and false imprisonment. It's just easier. You just work through that one, work your way on up, then to felony murder, then to malice murder. It's a suggestion. So what do we got? Criminal attempt to commit a felony, which is false imprisonment. What's an attempt? That's when you perform an act which constitutes a substantial step toward the commission of said crime. Mr. Bryan pulled out of his driveway and ran him into a ditch. Mr. Arbery was able to keep running. Right there, criminal attempt to commit false imprisonment. Criminal attempt to commit false imprisonment. This is actually what it says in the indictment. What do you have? In violation of the personal liberty of Mr. Arbery. Okay, guess what? We're citizens of the United States, right? We live here. We have personal liberty because this is a free country. Other people can't go up and stop us and hold us and detain us, okay? They have to actually have seen us commit that crime in order to effectuate a citizen's arrest. So you go around and you start stopping people, you're doing that in violation of their personal liberty. And what did they do? They unlawfully chased Ahmaud Arbery through the public streets of Satilla Shores in pickup trucks and did attempt to detain and confine him without legal authority on Burford using an F-150 pickup truck and a Chevy Silverado pickup truck. We all know that's what they did. False imprisonment. Now, this is over on Holmes. In violation of the personal liberty of Ahmaud Arbery, to unlawfully confine and detain Ahmaud Arbery without legal authority. Once again, did not see him commit any crime, not a citizen's arrest. They are not law enforcement officers. They are not in a marked patrol car. They are not with badges on their arms. They're not in any uniform. Without legal authority. Said accused did chase Ahmaud Arbery with an F-150 pickup truck and a Chevy Silverado pickup truck to the public roadways of the Satilla Shores neighborhood and did confine and detain him on Holmes. Travis McMichael said he was pinned between the two trucks. Greg McMichael said he was trapped like a rat between the two trucks. The ultimate false imprisonment. He never left Holmes, did he? Never left Holmes. Aggravated assault. Did make an assault upon the person of Ahmaud Arbery with a Ford 150 pickup truck and a Chevy Silverado pickup truck. I got a legal note here for you. Okay, you notice how it says and. Okay, but what do we know? Mr. Bryan's driving the Silverado. Travis is driving the Ford F-150. Greg McMichael is in the passenger seat at first. Then he's in the back of the truck. So, of course, it doesn't mean and, it's or. Okay, I know that sounds crazy. Don't you love lawyers? Don't you just love lawyers? Okay, and means or. So the way you should read this is with a Ford F-150 pickup truck or a Chevy Silverado pickup truck. Okay. So, what are pickup trucks? They are objects when used offensively against someone can result in serious bodily injury or death. You hit somebody with the F-150 pickup truck intentionally? You hit them with a Silverado intentionally? Are you going to hurt them? Break a leg? Paralyze them? You could even kill them. We all know that. Hit and runs, right? Vehicle homicides. We all know this. And the medical examiner told you so. Actual injury to Ahmaud need not be shown for aggravated assault with pickup trucks. The judge is going to instruct you. You don't have to actually hit the person. You don't actually have to injure them for it to be aggravated assault. What you have to do is place that person in reasonable fear of receiving a violent injury. This is really important, ladies and gentlemen. Did the defendants commit acts with their pickup trucks that placed Ahmaud Arbery in reasonable fear of receiving serious bodily injury? Yeah. Yes, they did. We know Mr. Bryan did. He ran him into a ditch, then tried to go at him again, then went out another time, then backed up toward him. Now, what did Travis McMichael get on the stand and said, oh, I just pulled up next to him. No, I didn't startle him. No, he wasn't afraid of me. Do you believe any of that stuff? Just look at the night owl video. Look at how Mr. Arbery tries to get away from them, and then look at them speed off after him. So all you have to do is look at that night owl video, and you'll know that they put him in reasonable fear of receiving bodily harm, violent injury, aggravated assault with pickup trucks. Aggravated assault in count 6. Did make an assault upon the person of Ahmaud Arbery with a firearm, a deadly weapon, that 12-gauge pump shotgun with 7 already in it. 2 steps. Pull the trigger. That's all you got to do. The evidence is that the defendants attempted to cause a violent injury to the alleged victim by shooting him. Yeah, that's aggravated assault with a shotgun. Now, I want to be really clear, okay? Travis McMichael does this with the shotgun. We see it on the video. This is the beginning of the aggravated assault. Beginning of the aggravated assault. The aggravated assault continues as he steps away from his car door and blocks the road. Now, what did he say to you? Oh, it's putting distance between me and Mr. Arbery. Was he putting distance or was he blocking the road? You decide. Then what does he do? He doesn't stay right there, does he? We can't see this, but what do we know? He makes it around that car door, right? He makes it over here, right? He's in front of his truck and he's moving forward. closing the distance on Mr. Arbery, intercepting Mr. Arbery, and is right here with that shotgun. It wasn't at court arms like this. It was right like this. And how fast does Mr. Arbery come around the corner? And boom, shoots him. That is one continuous aggravated assault ending in the shotgun blast to his torso, right here. You know, right here. Right? So how was he when the shotgun hit him? Like this. Right? Got it across the wrist, got it right in the torso, came out right here. So he's turned like this, according to the medical examiner. Felony murder. Felony murder is when you commit a felony and someone dies because of the felony. Classic felony murder scenario. Guy goes into a convenience store to rob the convenience store. He's not there to murder anybody. He's not there to kill the clerk. He doesn't know the clerk. So he's got a gun, right? So what does he do? Pulls out the gun and is pointing it at the clerk. And the clerk's like, and what does the clerk do? The clerk goes and tries to hit the gun away and starts punching at the armed robber, right? And then what does the armed robber do? Boom! Kills the clerk.
What done happened to the feed?
Because during the felony that you were doing, you pointed you were doing armed robbery, you pointed a gun at somebody. You expect when you're committing felonies, people are going to fight back, right? The convenience store clerk's entitled to fight back, right? Imagine if armed robbers could come in and go, well, I had to defend myself against the victim of my crime. Could you imagine if that was the law, right? I mean, but isn't that what they're saying? How dare Mr. Arbery defend himself against their 4 felonies? Isn't that what they're saying to you? So felony murder, let's take a look at it. What is felony murder? For felony murder, the state must prove that the defendant caused the death of another, check. By committing a felony, check, we got 4 of them. Do not need to show malice, okay? Meaning intent to commit the death of somebody. You know, like the guy showed up at the convenience store, he's not there to murder the clerk. Do not need to show he intended the death with the felony. What we have to show is this, that the felony directly caused the death. You pulled the trigger on the shotgun, aggravated assault with the shotgun, yeah, immediately caused the death, right? That's a no-brainer. But what about the other 3? You're sitting there thinking, okay, Linda, what about the other 3? What are we really talking about here? Did the other 3 felonies, aggravated assault with the pickup trucks, false imprisonment, criminal attempted false imprisonment, did they play a substantial and necessary part in causing the death? The state's position is, yes, they did. In other words, but for this felony being committed, the death would not have occurred. It's really easy. But for the felony being committed, this death would not have occurred. All right, so when does this really apply? The defendants are in the process of committing a series of felonies. They're doing it together at the same time. The defendants shoot Mr. Arbery during the commission of the felonies. Did that felony committed against Mr. Arbery ultimately contribute and lead to his death? So how do we look at this? Aggravated assault with a shotgun? Yes. Pointing that shotgun at him, having him run away around the side of the car, Travis McMichael intercepting him with the shotgun and then shooting him? Definitely aggravated assault, felony murder. Aggravated assault with pickup trucks. Well, once again, what do we have? Would he be dead if he hadn't been pinned between these 2 pickup trucks? Think about this. If he'd made it up Holmes and over on Zelwood, he'd have run out, right? If he hadn't been pinned between the 2 pickup trucks on Holmes, with Mr. Bryan running him towards the white pickup truck, would he still be alive? Yeah. Their use of the pickup trucks to go ahead and commit aggravated assault on him, put him in fear of them and their pickup trucks, meant he was running away from them. You saw it, running away. Did their actions, were they such that they put him in reasonable fear of receiving bodily injury? And did that contribute to him ending up where he ended up and his death? Yes, it did. Felony murder. False imprisonment on Holmes. That's what we're talking about. Did they falsely imprison him on Holmes? We've already gone over it. Had him pinned on Holmes, trapped like a rat between the 2 pickup trucks, according to Greg McMichael. He's still, after 5 minutes, running away from them. If they hadn't done this on Holmes, would he be alive? Ask yourselves that. If the answer is yes, felony murder. Check it off. Criminal attempted false imprisonment. So you're thinking, well, Linda, I mean, seriously, okay, that was over on Burford. I mean, yeah, they pulled up to him. Hey, stop, we want to talk to you. He runs away. They pull forward. They go down to the end of Burford. He then runs away from them again. They're trying to falsely imprison him over there. Did that contribute to it? Yes, because that's when they began their attack. They're using the pickup trucks over on Burford to put him in reasonable apprehension of receiving serious bodily harm, to put him in fear with their actions. What does Mr. Bryan do? Actually runs him into a ditch. Runs him into the ditch. Aggravated assault. So what's Mr. Arbery doing? We know he runs away from them, and runs away from them, and runs away from them. Because they have tried to falsely imprison him on Burford, and they've used these pickup trucks to do it. In a manner that's likely to cause him fear. We don't know what was going through his head. Nobody knows. That would be speculation. But you're allowed to look at it and go, were their actions such that it would put a reasonable person in fear of getting hurt? That's what you want to ask yourself. Those are the felonies in the indictment. So malice murder. What's malice murder? Well, cause the death of another person unlawfully and with malice aforethought. Now, malice aforethought is not ill will or hatred. It's not like what we think of. No premeditation is required, okay? Rather, it's the unlawful intention to kill without justification. Okay. Well, what's justification? Justification is self-defense. Deliberate intention to kill is one way you see malice murder. I'm deliberately taking your life. I'm killing you. How do we usually think about that? You're out to get somebody. You want the husband murdered for the insurance money. You're going to go ahead and execute somebody. You're mad at somebody. You're enraged at somebody. You intend to kill them. That's deliberate intention, right? But there's another kind of malice, and that's implied malice. You are allowed to consider this when looking at malice. You may also find malice when there does not appear to be significant provocation, and the circumstance of the killing shows an abandoned and malignant heart. Don't you love lawyers? What the heck is an abandoned and malignant heart, right? Well, think about that. You just don't care. You just don't care. What you're doing, you want to do what you want to do. And boy, whoever you're doing it to had better be okay with it. I'm going to order you to stop and talk to me. And if you don't, I'm going to pull out a shotgun on you. And hey, you're still going to run away from me? Oh yeah, I'm going to come at you. I'm going to intercept you over here at the corner. How dare you turn on me? Bam. Malice, right there. Remember, Mr. Arbery had to have engaged in significant provocation. What did he do? What did Mr. Arbery do? He ran away for 5 minutes. He ran away from them. Ran away from them for 5 minutes. That's what he did. Those hands out at his sides, and those baggy shorts he had on. No weapon, no threats, no way to call for help, didn't even have a cell phone on him. Ran away from him for 5 minutes. The state doesn't have to prove premeditation. The state does not have to prove motive. Okay? Not required to explain to you why they did what they did. You know what they did. Some of you may know why they did it. But the state does not have to prove exactly why they did what they did. The indictment. So here's the thing, party to a crime. How in the world could Defendant Brian be held responsible if he was in the Silverado filming all this, right? How can Gregory Michael be held responsible if he's in the back of the truck, finally on the phone with 911 when the shots ring out? Well, it's called party to a crime. And that's what it's called. So what's party to a crime? Well, ladies and gentlemen, let me ask you this. Do you think that everyone involved, from the person who actually commits the crime, to someone who encourages or enlists someone to commit the crime, to someone who helps commit the crime, should be held responsible under the law in Georgia? Do you think that sounds reasonable? Well, guess what? The law does. The law says everybody involved is guilty. Okay? Person is a party to a crime only if that person directly commits the offense. Driving the trucks, pulling out that shotgun, attempting to falsely imprison, helping to trap somebody by pinning them between two pickup trucks, running someone towards a man with a shotgun, all directly committing or helping in the commission of the crime, or advises and encourages. Well, what's advising and encouraging? Hey, Travis, get your shotgun. That guy is outside. Not, hey, Travis, I need to call 911. That guy is outside. Let's get our guns and let's jump in the truck. Encouraging. Advising. Cut him off, cut him off, cut him off. That's what Gregory Michael said. So that's what we've got. Ladies and gentlemen, how do you really want to think about this? Everybody gets a Super Bowl ring, right? The quarterback gets a Super Bowl ring. The guys in the field get the Super Bowl ring. The dude on the bench gets a Super Bowl ring, right? Everybody is involved. Everybody's responsible. That's what the law says. Cooperation after the fact. Now this applies to the defendants, but mostly young man and Mr. Bryan, because this has been brought up when he was talking to Agent Seacrest and everything. So first off, cooperation after the fact doesn't erase the crime you committed. Bryan did film the murder on his phone. He gave the phone over in the video right away to the police. He made statements to the police at the scene at Glenn County. He then goes and makes additional statements to the GBI in May of 2020. He consented to have his home night owl video downloaded. Guess what? Doesn't matter. Cooperation after the fact does not erase what you have done. Okay? That would be like two teenagers shoplifting at Walmart and one's filming the other, hee. Both of them are stuffing bikinis into their bag, right? The fact that one of them hands over her video of her girlfriend doing it, does that somehow make her not guilty of stuffing a bikini in her own bag? No, you still did the crime. So what if you were cooperative afterwards? Still responsible for your actions. This is about responsibility. All right, we're going to transition right now. I'm going to take a breath. We're going to transition into self-defense and citizen's arrest. Person is justified in threatening or using force against another person when and to the extent that he reasonably believes that such threat or force is necessary to defend himself or a third person against the other's imminent use of unlawful force. Wow, that's a mouthful, right? Yikes. Okay, let's break it down. Travis McMichael had to reasonably believe that it was absolutely necessary to defend himself. And of course, he threw in his dad, okay, which he never mentioned before at any point in time, but he threw him in on the stand, against the other's imminent use of unlawful force. That means Mr. Arbery had to be right there, imminently using unlawful force against Travis McMichael. Okay? It's the doctrine of reasonable beliefs, and the judge is going to go ahead and charge you on this. In other words, the belief that you have got to defend yourself, that it's life or death right here, right now, has to be reasonable. Okay? Guess who this standard applies to? Just take one guess who this standard applies to. Everybody. It applies to you. It applies to law enforcement. It applies to military people. Okay? It applies to Jason Bourne, Secret Service, CIA, FBI. It applies to everybody. There is no special exception for I was in the Coast Guard. There is no special exception for I used to be a law enforcement officer. The reasonableness applies to retired law enforcement officers, just like it applies to anybody. A manager of a store, okay, applies the same way. In other words, the reasonableness standard is set by society. You all decide whether this was reasonable or not. Travis McMichael's belief that he had to defend himself with lethal force has to be reasonable. So we got pointing a shotgun at Mr. Arbery when he's yards and yards away, had to be reasonable and necessary. But where's the imminent use of unlawful force by Mr. Arbery? What was he doing? He's running away from Mr. Bryan's truck. Mr. Bryan has already tried to hit him with the truck numerous times. He's trapped between two cars with no weapon. No way for anyone to help him because there's nobody out there to help him. He's not threatening anybody. He's just running away from the man with the shotgun. Look at this. I mean, take a look at this. He's not even up to those mailboxes on the side. And that's Travis McMichael pulling that shotgun up. Well, what are they going to tell you? They're going to tell you what Travis said. Oh, he was running toward me. And I could tell he was going to attack me. Is that reasonable? Who brought the shotgun to the party? Who took the shotgun out of the car? Who pointed the shotgun? The guy's running away from them for 5 minutes. Here's the thing, you cannot create the danger to yourself. That means you cannot be the initial unjustified aggressor. You can't create the situation and then go, I was defending myself. You just can't do it. He moved to intercept. He attacked him. I'm not talking about Mr. Arbery attacking Travis. All right, here's the concept of excessive force. And this is a big one, because here's the thing. If you use excessive force for your self-defense, guess what? You're not justified, you're guilty. Not justified, you're guilty if you use excessive force. Because it's force that exceeded what was reasonably necessary. You guys ever heard the term that's saying, you can't bring a gun to a knife fight? It's unfair, right? You can't bring a gun to a fist fight. It's unfair, right? You can't use excessive force. You can't call someone out and go, hey, buddy, let's take it outside. You're starting it. And then when that person starts to beat you up and is better at the fight than you, you don't get to pull out a gun and shoot them. You started it. You called them out. They're better at this than you. And all of a sudden, you're like, I'm scared. I have to defend myself. That's not the way this works. Excessive force. So first off, Ahmaud had to be using unlawful force against them. Remember the guy running down the street right here? He's using excessive force. He's using unlawful force against them right here, right? Then Travis McMichael had to reasonably believe that he had to defend himself against Mr. Arbery. And they're going to get up here and things, ladies and gentlemen, they're good. These defense attorneys are good. They're going to get up here and they're going to make it perfectly, they're going to make this seem like, oh yeah, this is scary. And Travis had to pull a shotgun out on him. They're going to make it seem so reasonable. Put on your critical thinking caps. Use your common sense when they're up here giving their closing arguments. The amount of force has to be reasonable. Unarmed man running with hands at the sides, never pulled out a weapon, never threatened anybody. This is completely excessive force. Even if you think, ladies and gentlemen, even if you go, hey, it was a citizen's arrest, hey, he was really defending himself, you then still have to go, this wasn't excessive force in order to find them not guilty. All right? What you didn't hear from the defense in their opening statement are the 3 instances when a person can't claim self-defense under the law in Georgia. Can't be the initial unjustified aggressor. This is important. You can't start it with your driveway decision, unjustified, because you didn't see a crime committed that day, and then claim, oh, I acted in self-defense. What's their justification? What are you going to hear? We wanted Ahmaud Arbery to stop and talk to us, and he wouldn't. So we tried to force him to stop, and then we killed him. I mean, that's really what they're going to get here and tell you. They'll probably make it seem much more palatable and okay, but that's really what they're going to tell you. You can't commit felonies against someone and then claim self-defense. You can't be the armed robber in the convenience store pointing the gun, and when the clerk goes to defend himself by grabbing that gun or hitting an armed robber, you can't shoot him. The law goes not self-defense when you're committing felonies against someone. And you can't provoke someone into defending themselves against you so that you can intentionally harm them and then claim self-defense. Okay, what's that about, ladies and gentlemen? Think of your schoolyard bullies. Think of the 3 boys walking behind the one who's the target, kid who's getting abused, right? Okay, so you got 3 on 1. They're going down the hallway. They're menacing him, maybe threatening him. And they get him up against a locker, and he has nowhere to go. He's trapped, right? So what does the kid who's being bullied do? He takes it, and he takes it, and takes it until he can't anymore. And he finally shoves the one bully. And what does that bully do? Bam! Punches the target child, right? What's the bully always say? He started it. Isn't that what the bully always says? He pushed me. I was defending myself. Yeah, 3 on 1 with one kid up against a locker. You're bullying him. And he actually pushes you, and you get to then claim you were acting in self-defense when you punch him. Guess what? The law knows people do this. I mean, this is the law. The law knows people will go to other people into defending themselves so that they can claim, I was acting in self-defense. You can't do that either. 3 on 1, 2 pickup trucks, 2 guns, unarmed. Mr. Arbery was unarmed. So what are you going to hear? I don't know what they're going to say. They're good. They're good defense attorneys. They're going to get up here, and the state is so worried that they're going to make it seem so reasonable that everything that Travis did and Greg did is just so reasonable. I'm just going to ask you, use your common sense and put your thinking caps on. But this is what we anticipate they're going to say. The victim started it, or you're going to hear that he was the aggressor, okay, because he was running towards Travis McMichael, but he was running away from Mr. Bryan, who'd already tried to hit him with the pickup truck. And Greg McMichael said it. He was trapped like a rat. He knew there was nowhere else to go. Or they're going to tell you that, ladies and gentlemen, this is really about the front of the pickup truck. Forget everything else. It was all about the front of the pickup truck. And they're going to try to make it seem like, well, he attacked Travis McMichael. He very well might have. We can't see. What we know is his hand was like this, right? Doesn't matter. You know why it doesn't matter? Because they weren't committing a citizen's arrest. They weren't in fear, real fear, of imminent danger from Mr. Arbery. They were committing the 4 felonies. That's what they were doing. You're going to hear, we weren't committing felonies. We were doing a citizen's arrest. We weren't trying to provoke him into defending himself. You're probably going to hear this. Yes, we pointed a shotgun at him to get him to comply with our orders. Not sure why anyone should comply with their orders to stop and talk to us, but there was no reason for him to defend himself against us because this was a citizen's arrest. Ladies and gentlemen, this is the bottom line. As I said in opening, I'm going to say it to you again. This was an attack on Ahmaud Arbery. They committed the crimes. They committed the 4 felonies. They attacked him. They shot and killed him. They can't claim self-defense under the law because they were the initial unjustified aggressors and they started this. And they were committing the felonies against Ahmaud Arbery. They have to somehow justify their actions by claiming citizen's arrest. I'm going to remind you once again, evidence from the witness stand, they never, ever said on February 23rd, 2020, that they were doing a citizen's arrest or trying to arrest him. It was all, we wanted to stop, we wanted to question him about what he was doing because he must have committed a crime that day, and we were going to hold him so the police could go back and figure out what crime it was that he must have committed because he was running down the street. Citizen's arrest. If the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping, a private person may arrest him. So what are they going to do? They're going to do this. Oh, I'm sorry. I forgot to tell you this. A private person may not act on the unsupported statements of others alone for their probable cause. What does that mean? No gossip, no hearsay, nothing along those lines. In other words, my about this, where she has no personal knowledge of it, doesn't count. That's unsupported, unreliable statements of somebody else. You have to have more than stale information from an unreliable source. A private citizen's warrantless arrest must occur immediately after the offense, or in the case of felonies, during the escape. If the observer fails to make the arrest immediately after the commission of the offense or during escape in the case, his power to do so is extinguished. What does that really mean? A citizen's arrest is for emergency situations when the crime really happens right in front of you and you can take action right then and there to arrest somebody because you know about it. You've seen it. You're taking action right then and there. If it's a felony, you can run after the person and chase them down. That's all this means. So it's not a citizen's arrest. They never said it. None of the defendants saw Mr. Arbery commit any crime that day. They were detaining him for the police so that they could investigate and find the crime that he must have committed that day because what is he? He's running down the street. That's not the law, ladies and gentlemen. Not the law at all. Travis McMichael, remember all his assumptions? He got up here and I wrote them all down. He may have run by. Matt Albenzi may have seen him. He may have broken in. Maybe the owner's down there. He may have been caught. He may be trying to avoid the police. That's testimony from the witness stand. He didn't know anything. Absolutely nothing. So where are we going to end up? This is where we're going to end up. Travis McMichael had probable cause to believe that Ahmaud stole the stuff off the English boat in 2019 because his mother gave him some gossip about stuff being stolen, and he was escaping. Use your common sense. How do you escape from a crime on an unknown date in 2019 on February 23rd, 2020? I'm sure they'll explain it to you. But use your common sense. And remember, what do you think? You think all this was completely made up for trial? Especially given no one ever said it on February 23rd, 2020? Ladies and gentlemen, use your common sense. Put your critical thinking caps on. It's all the state can ask you to do. Ladies and gentlemen, I give you the defense.
All right. What we're going to do, ladies and gentlemen, is take a short recess. Let's go ahead and take a 15-minute recess, and then we'll come back for the continuation of closing arguments. Again, do not discuss this case amongst yourselves until all of the closing arguments have been made and you have received the final charge of the court. All right. So again, 15 minutes, and we'll see you back. Thank you.
All right, y'all. So the state has given their closing argument, and I just really feel like Sister Prosecutor really gave all the explanations on all the levels. Like, she gave you the legal, she gave you the dummy version, she gave you the preschool version, she gave you the kindergarten version. You cannot commit a felony and then claim self-defense. It's not. It's comical it's comical to me to even think that these people are standing here or sitting in here trying to say that they were acting in self-defense. Like, yeah, Linda kind of did her big one on that one. So we're gonna give a couple snaps to Linda for doing her thing. All right. So I'm gonna try to get us, I don't know how long the defense is, at least the first defense attorney's closing is. So he starts here. And then he goes a while. Okay, because we had an issue at school, y'all, and one of the kids about to get off the bus, and I gotta have a conversation with them before anybody else get in here. So I know we had a short day today. But your girl had things to do, and I think we're gonna have a shorter day. We might have a short day tomorrow too. I should be able to start a little bit earlier, not as late as 12. Yeah, they come first. Definitely come first, KP. So we won't start at 9, right? We'll probably start somewhere around 10:30, 11 Central tomorrow, and we'll just pick back up with the defense is closing. Yeah, they would. Yeah, like when somebody got to have a conversation. It's the oldest one too, so got to talk to her before everybody else get her. Which only gives us like a 20-minute conversation for a conversation that should be an hour long. So we'll see. We'll see. But yeah, so, and I'm sorry about our calendar, y'all. Y'all know I chipped my tooth over the weekend and I was distraught. Oh shoot, tomorrow I got a dental appointment too. So I'll figure us out. Yeah, for sure, Trees. So I'll figure it out because I want us to be able to sit and get through all of the defenses closing before we do reclosing. So if we don't, we'll figure it out tomorrow. We may have a little split schedule tomorrow, but we gonna get through it. And then that's Thursday. Ooh, you know what? Because if ASAP Rocky start tomorrow, all right, let me figure it out. What I'm gonna do is I'll figure out if they think that ASAP Rocky is gonna start tomorrow. Because if he starts, we could, because I'm gonna stream on Saturday too, y'all, because we missed Monday. I'll figure it out. But I will holler at y'all later. Thank y'all for sitting in here jamming with me today, and thank y'all for listening to my law school visit story because I'm about to tell it like 4 more times before the day is out. But everybody stay safe, stay warm. And I will see y'all later.